Hello, everyone. Remember that the state was seeking the death penalty against hitman Sigfredo Garcia. This covered the penalty phase.
The parties have any legal issues we need to take up? Start with the state.
Not at this time, Your Honor.
You're saying it?
No, Judge.
I wanted to discuss a couple of things. First, what aggravating factors is the state going to be proposing as being involved?
You want to say up or down, Your Honor?
Up.
Okay. The prior violent felony is one we're looking at. We're not enough final details of that, Your Honor, but
I'm sorry, you need to.
of the proposed instructions.
Right.
Number one, the previously convicted of a felony involving use of threat or use of violence to a person. I believe there's prior robbery conviction. The capital felony was committed for pecuniary gain. I think the evidence supports that. The HAC, the CCP, and the felony was committed by a criminal gang member.
All right, well, let's talk about 3, heinous, atrocious, and cruel. I assume you're aware there's a myriad of cases that say simply a shooting is not heinous, atrocious, and cruel. What's the state thinking on that?
Your Honor, that the victim looked up, saw that he was fixing to be shot, so he was aware that something was fixing to occur, and that's even demonstrated by the physical evidence, the fact that he was shot between the eyes, and the fact that he was talking on the telephone where he was aware someone was coming up. After he was shot, the neighbor, Mr. Gaynor, I believe, came across the street and testified and observed the victim writhing in pain in the front seat of the car. And then he lived a while after, he lived a number of hours and then passed away.
Well, I guess you're aware there are a number of cases that have facts at least that bad that have found that heinous, atrocious, and cruel and it's not applicable. I'm not going to make a final ruling now, but I can tell you I'm unlikely to give that to the jury. So if you think that's a valid aggravator, you're going to need to show me some case law that says other than the case law that I'm aware of. If you need any of these sites, I'd be glad to give you these sites, but I assume they're not hard to find. If you want any of the sites?
Give me the one you're most relying on, Your Honor.
Well, I've got several of them, but Teffa Teller, v. State, 439 Southern 2nd, 840. Rivera, v. State, 545 Southern 2nd, 864. Morris, v. State, 531 Southern 2nd, 1256. Lewis, v. State, 377 Southern 2nd, 640. Shear, v. State, S-H-E-R-E, v. State, 579 Southern 2nd, 860. 579 Southern 2nd, 886, I'm sorry. I'm sure there are a whole bunch more, but those would get you on that line of sights.
Yes.
On the gang issue, you understand there's binding precedent that has found the statute unconstitutional, as did the underlying statute for which that they're relying upon for the definition, 87403. I assume you have that cite?
Yes, sir, but while the definition may be unconstitutional, I don't know what the aggravator itself is.
Well, there's never been a case on it, but when it says that it's unconstitutional to punish someone for gang membership without a nexus to the criminal activity, that is binding precedent. Do you want that cite?
Yes.
State v. O period, C period, 748 Southern 2nd, 945, Florida, 1999. So is the state going to be able to show some nexus between the gang membership and the criminal activity in this case?
It's possible, Your Honor. I think they're maybe doing some final discussions about that.
Right.
So that would probably be one that we were aware we can address, because Councilman and I had discussed that. And that's some of the conversation that's going on this morning.
Well, I can just put you on notice. I'm not making any final ruling, but if there's no showing of a nexus between gang membership and this crime, I'm unlikely to include that aggravator based upon that case law.
That's, we anticipated that was possible, Your Honor.
All right. Anything else on that issue, Mr. Sanganet?
Yes, good morning, Judge. Salam Zang on behalf of Mr. Garcia. I'm a little confused as to the government's position with regards to the gang activity. Their witness, Mr. Rivera, made ample he clearly said this is about me, and
We don't need to get too deep into the facts. I'm just putting it out there that there's the case law.
I understand, correct.
We'll see what they present, and we'll argue about it after it's closed. And the way I view it, so y'all can understand, it's essentially a judgment of acquittal argument as to an aggravating factor. So we'll see if they have evidence that supports the nexus. But I didn't want to surprise anybody with case law that I was looking at.
Yes, Judge. No, I'm in agreement with the court's position as to the two aggravators. I have no additional argument.
Right. What mitigating circumstances are you looking at? Did we put them in there accurately, or what you were requesting?
Yes, Judge. We requested under the statute B, subsection B, which is a capital felony was committed while the defendant was under the influence of extreme mental or emotional disturbance. D, the defendant was an accomplice in the capital felony committed by another person, and his or her participation was relatively minor. E, that the defendant acted under extreme duress or under the substantial domination of another person, and obviously then H.
All right, I think that's what we've included in this.
Yes, Judge.
I assume both sides got the proposed instruction.
Yes, Judge.
Mr. Evans?
Well, Ms. Kappelman may have gotten, I got the first one that I don't think included.
There's a more recent
I can forward it to him.
version out there. I don't know for sure who best did that too, but it may have gone to Ms. Kappelman, so you need to make sure you get that.
I just forwarded it to him, Judge.
What's that?
I just forwarded him my copy.
Okay.
Thank
All
you.
right. Okay. All right. So just want to get those things out there. So any other legal issues we need to deal with?
Not for Mr. Garcia, Judge.
This is, I think, a little bit more a legal procedural type issue, Judge, but you're not going to indicate whenever we first, during your initial instructions about any of the possible aggravators, are you?
No, I'm following the standard preliminary instruction, which does not include any direct discussion of what the aggravators or the mitigators are. It just tells them the process.
Yes.
Okay. I assume y'all looked at the standard instruction.
Yes, that was the reason I was asking. We're going over these today, and then I just wanted to.
No, I just wanted to get a little start on the legal issues that I see.
Yes.
Anything else legal wise?
No, Judge.
So, Mr. Sangaday, what are you anticipating in terms of evidence?
Well, we're going to be calling our mental health expert, Dr. Harper.
Who is it?
Dr. Julie Harper, Judge.
Harper.
Yes, Judge.
And how long are you thinking on that?
1 hour, Judge.
And Mr. Garcia is again going to have an opportunity to testify if he chooses. Just to make sure y'all have whatever discussions need to be had on that issue. So
Yes, sir.
again, if he chooses not to, I'll colloquy him on that. So I don't want to catch anybody by surprise. So what's the state anticipating?
Your Honor, we're anticipating a victim impact statement. Given we have asked that the victim's family members basically do a combined victim impact statement, and that one of the family members will read it, since it's not an aggravating factor, and that's
How are you envisioning doing that?
we envision getting basically we'll have a written statement that will be read by one of the family members from the stand.
Okay.
And we'll get a copy of the statement to the court and to the defense.
Okay.
For any objections ahead of time, so we may.
Because you know that's a tricky area of the
Yes.
law in terms of what can and can't be said in a victim impact statement. We need to make sure we don't run afoul of that.
We're trying to do our best to vet it ahead of time, so there will be minimal or no changes in it once the court
Okay.
and counsel.
Has it been decided who's going to read it?
I don't think so as of yet, Your Honor.
All right.
But we'll nail that down.
But get that to us as soon as you can, please. What else are you anticipating?
On the game issue, there may be testimony from Mr. Rivera or some other aspects of the crime. He's a possible witness, Your Honor. And then that would probably be the two witnesses for the main part of the state's case. And the second part would be the rebuttal with Dr. Pritchard, the mental health expert. And Mr. Rivera may or may not be called during that part of it as well.
So you have some prior records you're going to be trying to establish.
Yes, I believe there's one adult conviction for a robbery that we have. We have a copy of the judgment sentence and the on it, but I don't anticipate any live testimony regarding that.
Okay. Have y'all discussed identity on the judgment sentence for robbery?
No, we've not discussed it yet.
We'll see if we can reach a stipulation on that. If not, who's going to document that?
It'll be Mr. Balboni, Your Honor. But since both, I don't know if we're going to have any issues with this. I think both experts are relying on Mr. Garcia's prior history, so I don't know that any of it would be in dispute.
Well, if it's going to go in evidence, then we're going to need to have evidence of that. Mr. Sanguinet, have you looked at what they're proposing in terms of a prior judgment sentence?
I'm aware of the case. I just haven't seen the certified
All right.
documentation of it.
Certainly move things along if it's undisputed that we arrive at some stipulation as to identity on the prior judgment and sentence. But I'd ask that you'll discuss that. If that's workable, let's do that and save having to have Mr. Balboni testify. Right?
Yes, Your Honor.
All right.
Yes, sir.
Okay. Anything else? So how long are you thinking, Mr. Evans?
I would think probably about 30, 45 minutes at the most for the first part, and about an hour with the expert, simply because that will vary to some degree depending on what.
I understand predicting the experts a little bit first. What I'm hoping that we can finish the evidence this afternoon and plan to do instructions and closing in the morning. That's my hope. We'll kind of have to see how it runs, but that's my game plan if things work.
Yes, sir.
That seemed to be doable.
Yes, sir.
Let's
Yes,
hang it in.
Yes, Your Honor.
All right. 1 o'clock, we'll start with the jury if there's nothing else.
Nothing else, sir. Oh. I just want to make sure that what it says is what I have on the clerk's page. I pulled it up. All it has is that one line.
It's from around each section.
Okay. It doesn't show the sentence.
I think it does, I think it's one day.
Yeah.
It's,
Okay.
I don't know, I think it does.
What?
So we're fine with that. We don't have to worry about it. What else do we have? I don't know.
Oh, fixing.
I'm gonna lock this up.
You know,
So I
you know,
don't need to hear.
that way we get to right here at one.
You want the one that's in there.
No, please.
Yeah, Shannon. Dr.
I can run with it. I can look at it. So yeah, we do have an issue for him. Unless y'all want to consider. We agree to get.
Well, they're there, this one here, we had one here, and one here, this one here. And these are the ones that we agreed on. This is that.
I really haven't.
All right. Fourth line session, Honorable Judge James C. Hankinson, for life.
Ready for the jury?
Yes, Judge.
Let's have a jury, please.
All right, for the jury.
Everybody be seated, please. Good afternoon, folks. Thank you for being back here this afternoon. Appreciate you being prompt. We're now ready to proceed into what would be deemed the penalty phase. You found the defendant guilty of first-degree murder. The punishment for this crime is either life imprisonment without the possibility of parole or death. The attorneys will now have an opportunity, if they wish, to make an opening statement. The opening statement, as I've told you before, gives the attorneys a chance to tell you what evidence they believe will be presented. What the attorneys say during this statement is not evidence, and you're not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence relative to the nature of the crime and the defendant's character, background, or life. You're instructed that this evidence, along with the evidence that you have heard during the guilt phase of the trial, is presented in order for you to determine, as you will be instructed, whether each aggravating factor is proven beyond a reasonable doubt, whether the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify the imposition of the death penalty, whether mitigating circumstances are proven by the greater weight of the evidence, whether the aggravating factors outweigh the mitigating circumstances, and whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. At the conclusion of the evidence and after argument at counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is a standard to guide the jury in making the choice between a verdict of life imprisonment without the possibility of parole or death. It is a statutorily enumerated circumstance that increases the gravity of a crime or the harm to a victim. You must unanimously agree that each aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your final verdict. In order to consider the death penalty as a possible penalty, you must unanimously determine that at least one aggravating factor has been proven beyond a reasonable doubt. The state has the burden to prove each aggravating factor beyond a reasonable doubt. A reasonable doubt, as you've already heard, is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in providing your verdict on the appropriate sentence to the court. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, conflicts in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that the aggravating factor does exist. Before moving on to the mitigating circumstances, you must determine that the aggravating factors are sufficient to impose the sentence of death. If you do not unanimously agree that aggravating factors are sufficient to impose death, do not move on to considering the mitigating circumstances. Should you find sufficient aggravating factors do exist to justify the imposition of the death penalty, it will then be your duty to determine whether the aggravating factors that you unanimously find to have been proven beyond a reasonable doubt outweigh the mitigating circumstances that you find to have been established. Unlike aggravating factors, you do not need to unanimously agree that a mitigating circumstance has been established. Rather, whether a mitigating circumstance has been established is an individual judgment by each juror. A mitigating circumstance is not limited to the facts surrounding the crime. It can be anything which might indicate that the death penalty is not appropriate for the defendant. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that reasonably may indicate that the death penalty is not an appropriate sentence in this case. A mitigating circumstance need not be proved beyond a reasonable doubt by the defendant. A mitigating circumstance need only be proven by the greater weight of the evidence, which means evidence that more likely than not tends to prove the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you may consider it established and give that evidence such weight as you determine it should receive in reaching your conclusion as to the sentence to be imposed. At this point, we'll move into the opening statement.
May it please the court, counsel. That was the jury. You have found the defendant in this case guilty of first-degree murder. At this point, the law allows for two possible punishments, as the judge has just instructed you. That's life in prison or death. The state has presented about 9 days of testimony. I know you all paid very careful attention and went over that evidence in an agonizing fashion back in the jury room. And we're going to ask you to consider some of that testimony again in making a decision as to whether or not aggravating factors have been proven in this case. The state's alleging that two aggravating factors are present here. One, that this murder was committed for pecuniary gain. That means they did it for money, for greed. You've already heard about the payment that this defendant received for his portion or role in the crime. And you've heard about some of the items that he bought with that money. So I'm going to ask you to consider that evidence when you're weighing whether or not this crime was done for money. The second aggravating factor that I'd like you to consider is that this murder was committed in a cold, calculated, and premeditated manner. You've already found that this is a premeditated first-degree murder, but this aggravator is a heightened level of premeditation. And I've argued in closing argument that this is about as premeditated a crime as they come. And I'm going to ask you to reconsider some of the evidence about the preparations that were made in reference to this murder. So the first trip, the drive up, purchasing of the gun, all of the phone communications that you saw, the stalking behaviors that were seen at both Premier Gym and on the bus video and testified about by Mr. Rivera, the way that they really hunted and cased the scene there and hunted down Mr. Markel and ultimately shot him in cold blood. Today, we're going to hear from Ruth Markel, Daniel Markel's mother, and she is going to read for you a victim impact statement on behalf of Mr. Markel's friends and family and his community to give you an idea of his uniqueness as an individual. At the conclusion of the presentations today, you will be convinced beyond a reasonable doubt that these two aggravating factors do exist, and then it'll be within your province to make a consideration as to whether these aggravating factors outweigh the mitigating factors and whether or not death is an appropriate sentence in this case.
Mr. Secretary.
Thank you, Your Honor. Judge Hankinson, Ms. Kaplan, Ms. Norris, ladies and gentlemen. We talked about mercy in jury selection, and that's where we are. And that's what we're asking for. We're asking for you guys to remember the facts of the case, for you to have a recollection of certain individuals that testified, for you to have recollections of how the case moved. I want you to recall strategies used by certain members of the defense and not used by others. You're going to hear more about Mr. Garcia today. You're going to hear about his life. You're going to hear about his childhood. You're going to hear about his father. You're going to hear about how he's been shot, how he's been in multiple accidents. And you're going to hear these things in a vacuum, okay? But I want you to listen to them because they're important, because it allows you to understand some of the mitigators that we are going to be arguing for you. Because while the government has indicated that they're going for 2 aggravators, which is pecuniary gain, which is money, and they're also going for a definition that this was a cold, calculated, premeditated. With regards to the pecuniary gain, it's a lot like the solicitation charge that you guys were asked to determine with regards to his innocence or guilt. You have to take into consideration the same factors. With regards to the cold, calculated, and premeditated, we will have mitigators for you to consider. Our mitigators will include the following. We will ask for you guys to consider that the capital felony was committed while Sigfredo Garcia was under the influence of extreme mental or emotional disturbance. We will also ask you to consider this mitigator, that the defendant was an accomplice in the capital felony committed by another person, and that Sigfredo and his participation was minor in comparison to the other person. We will also ask you to consider that Sigfredo acted under extreme duress and substantial domination of another person. We believe the facts from the case and the manner in which defense strategies came out in the case will substantiate that argument. And then, like I indicated before, we're going to tell you more about Sigfredo's life. Okay. And all we can ask is for you guys to be human, for you guys to understand that even if you find there's an aggravating circumstance here, you don't have to find death. Aggravators just get you to the next level. And that ultimately you guys can look at this case and say, is this the case? Is this the type of case with his role and the big picture that he should get a needle? And we submit to you the answer is no. Thank you.
Call your first witness, Mr. Shepard.
State calls Ruth Markel.
Let's go sidebar, please. Ms. Markel. We got our third arrangement of microphones. We've been trying to work out the microphone situation. So far, the other two have not been satisfactory. So this is not the courtroom that I normally present cases in. So anyway, hopefully we've done better. If you face the clerk and be sworn, please, ma'am.
You solemnly swear your testimony will be the truth, the whole truth, and nothing but the truth.
Yes,
Have a seat and slide up the microphone, please, ma'am.
there is no mic, is there, Mike?
It's up there in front of you.
Ma'am, what is your name?
Ruth Markel,
Please spell your name.
Ruth Markel.
Ms. Markel, how are you related to Daniel Markel?
I'm his mother.
I'd like to approach with what I've marked as State's Exhibit 197.
Yes,
Recognize State's 197?
yes, I do.
How do you recognize it?
This is Danny with his older son Benjamin and his younger son Lincoln.
This is a fair and accurate photo of your son and his two children.
Definitely, yes.
Judge, at this time, I'd ask to introduce State's 197.
Any objection?
No objection.
I'll be admitted. You may.
Mrs. Markel, have you prepared a victim impact statement for the jury here today?
Yes, I have.
I'm gonna approach and show you what I've marked as State's 198. Recognize State's 198?
Yes, I do.
Is that a fair and accurate copy of the statement you intend to read today?
Yes,
Judge, at this time, I'd ask to introduce 198 as a court exhibit only.
Any objection?
No, Your Honor.
All right. It will be admitted as a court exhibit.
Give us just a moment to get our equipment going.
And Ms. Markel, I would ask that you stick to the reading what is said and not ad lib from it, please.
sure. Thank you.
You have a copy?
I do.
She has a copy, Judge. All right, Mrs. Markel, you may proceed.
My name is Ruth Markel. I am Dan Markel's mother. I am reading the statement on behalf of my family. Parents are not supposed to outlive their children. A mother should never have to bury her own child. Perhaps this is why there are words to describe someone who loses a spouse or their parents, a widow or an orphan. But there is no word in the English language for someone who loses a child. And yet, because of the acts of a few, my son Dan's life was cut very short, and I have been forced to experience the unthinkable and to live a life filled with unimaginable pain and heartbreak that no mother should ever have to endure. Dan's family, friends, and colleagues and mentors describe Dan as a caring, uplifting, and inspiring person to everyone around him. Dan was a devoted son and family member, cherishing family celebrations and always making time for lengthy phone calls with us and other family members in Canada, the United States, and Israel. As a son, everything about Dan and everything he did made us proud. From his love of music, dance, sports, and travel, to his dedication to and hard work in school, culminating in his acceptances into Harvard University. As an undergraduate in Cambridge, England, where he earned a master's degree in political theory, and finally Harvard Law School, where he received his JD and began his impressive legal career. After graduating law school, Dan served as a law clerk for a federal circuit court judge, and then worked as an associate at a prestigious law firm in Washington. DC. Then began what proved to be a successful career in academia, becoming a professor of law and landing a coveted teaching position at a top U.S. school right here in Tallahassee, FSU College of Law. Of all my son's accomplishments, however, I am most proud of the father Dan was to his beautiful boys, Lincoln and Ben. It is hard to capture in words the joy and excitement I felt when Dan became a father and I became a grandmother. I derived even more joy and happiness watching Dan raise his two boys. Dan was a present, devoted, loving, supportive, selfless father, and he always acted with the best interest of his boys. Dan regularly attended the boys' daycare, leading holiday programs for all the children. Dan's office and home were covered with the boys' drawings, and the family's living room was always full of the boys' toys. Regardless of the situation, Dan always put his children's safety and well-being ahead of his own. Lincoln and Ben loved their father. He was their hero. Dan offered the world his love, his wisdom, opinion, his energy, his friendship, and his warmth. Since the day he was born, Dan was alert and energetic. He did not waste this energy. He used it to live life to the fullest. For example, even in his short life, he pursued his passion for travel, and he lived in many cities: Montreal, Toronto, Boston, New York, London, Jerusalem, Washington, D.C., Phoenix, San Francisco, Miami, and Tallahassee. He made many friends all over the world and continued to stay in touch with everyone he befriended. When Dan moved to Tallahassee, he quickly became an integral part of the community. Dan made many close friends at FSU and in the broader Tallahassee community. He regularly attended community events and frequently hosted others at his home. Dan was on the board of the Shomrei Torah Synagogue and frequently attended services, holidays, and children's programs. Dan's murder has not only deprived his large network and community of a dedicated and caring family member and friend, it has also deprived the world of a brilliant attorney, teacher, and legal academic. Dan also co-founded a blog called Prof's Blog, which focuses on a variety of topics related to law and life. Due to Dan's amazing dedication and tireless work, Prof's Blog continues to grow and inspire legal scholars and students around the world. In addition to Dan's scholarship, Dan was a devoted professor who was deeply involved in the FSU community. Dan was passionate about teaching, and his students adored him. Dan served on the law school's recruiting committee and worked to recruit high-level academics to FSU, including by personally hosting most of the recruits and new faculty members. Dan's energy, drive, and sociability enhanced the student body and the faculty of the FSU College of Law. As the court knows, Dan's life was brought to a sudden, abrupt, and tragic end when he was murdered in July 2014. The losses sustained and the damage caused by this crime cannot be overstated. In one fell swoop, our son, brother, and the father of two young boys were all killed. My life was shattered. Dan's death has caused us deep pain that is both disruptive and permanent. After the death of a loved one, you are supposed to face the loss, the void, the experience, the grief, and maybe get closure if you are lucky. When you lose a child, life's progression comes to a complete stop. And the grief comes to a grief stop. When my life was shattered, Dan's death has caused this deep pain that is both disruptive and permanent. After the death of a loved one, you are supposed to face the loss, the void, the experience, the grief, and maybe get closure if you are lucky. But when you lose a child, life's progression comes to a complete stop, and the grief and pain of a mother who loses her child never ends. For me, closure and normalcy are only words in a dictionary, not a reality that I will ever experience again. We have waited for more than 5 years for those involved in Dan's murder to be brought to justice, which has only exacerbated my pain, grief, anxiety, and health. It is very cumbersome to navigate and participate in the legal processes encountered in the days, weeks, and years following the murder. From the day I learned about Dan's death, I experienced a life sentence. But I know that even after justice occurs, Dan's murder will continue to torment me for the rest of my life.
Thank you, Mrs. Markel.
I'm not finished. Wait, I'm still sorry. Other lives were
Wait,
just.
stop.
What's wrong?
Oh, there is another page. It just looked
Okay.
like the end.
Okay, are we okay? Yeah.
Sorry, go ahead.
Sorry.
Yes, ma'am.
Other lives were destroyed as well. The lives of Dan's two sons, my grandchildren, were forever turned upside down as a result of this crime. Benjamin was 4 years old, and Lincoln was only 3 years old when their father was murdered. Benjamin and Lincoln have been forever deprived of a relationship with their father and will grow up and go through life without a father. These boys have also been robbed of their childhoods as they are forced to confront and try to understand the unthinkable crime of murder at such a young age. We, all including Phil, Shelley, and her family, have been traumatized by Dan's tragic death. Dan's nieces and nephews, ranging from ages 8 to 13, were forced to confront murder at a young age. Dan's older relatives could not comprehend this tragedy. My maternal 97-year-old uncle had a special bond with Dan and suffered greatly from his murder. He gave up and died 3 months later. There is not a single day that goes by when thoughts of Danny do not enter our minds. His murder has been horrible for us, shocking, surreal, hard to understand. Danny is never coming back, but we continue to hope and pray for justice.
All right, thank you.
You can step down. Thank you.
Thank you.
Next one.
No further witnesses, Your Honor.
Mr. Sanganet?
Yes, Judge, the defense calls Dr. Julie Harper to the stand. Mr. Padilla will be conducting.
Somebody will need to get her. She's
Right there, Your Honor. Come on.
Come on up, man.
Your Honor, can we approach sidebar?
Sure.
Grace Clerk, be sworn, please, ma'am.
Do you solemnly swear or affirm that the testimony given in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Have a seat, slide it back, front, please. May proceed.
Good afternoon, doctor. My name is Mauricio Padilla. I represent Sigfredo Garcia. I'm going to ask you a couple questions today, okay?
Yes.
Could you please state your profession and your name for the jury again?
Dr. Julie Harper. I'm a clinical and forensic psychologist, a licensed psychologist in the state of Florida.
And what is your educational background?
I have a biopsychology degree from Oberlin College. That's a bachelor's degree. I have a master's degree in clinical psychology. That's from the University of Denver. I have a psychological doctorate that's called a PsyD from University of Denver. I attended an AP-approved internship in Washington State at the Washington State University. I continued on and completed postdoc hours in Washington State, and I was first licensed there in 2002. I moved to Florida and was first licensed here in 2005. And then in 2017, I was first licensed in Georgia.
And you mentioned the University of Denver. Is the University of Denver accredited through the American Psychological Association?
Yes, it's an APA-approved program.
And can you briefly explain what the American Psychological Association is for the jury?
Yes. So in the formation of qualified graduate schools, they have rigorous standards for study, scholarship, and certain core concepts that they want to ensure their graduates know before they leave for internship. And that is a rigorous process of being accepted. So if your graduate school has that accreditation, then it's been deemed by those that evaluate those programs to be a school that has stuck to the goals of psychological education.
So you are a licensed psychologist, correct?
Yes.
Just to be clear.
Yes.
Let me show you. Judge, may I approach?
You may.
I'm going to show you what's been marked as Appendix 9 for identification. Could you look at this document?
Yes.
Do you recognize that document?
Yes, that's my curriculum vitae.
Okay, and is it an accurate depiction of your CV?
Yes.
Your Honor, I'd like to move this into evidence at this time.
It's been marked as what?
As Defendant's 9.
I don't think that's appropriate to go to the jury. See, certainly for the court purposes, it'd be helpful to have her vita in the record, but if you're asking it to be a record, an evidentiary value to go to the jury, I don't think that's appropriate.
Okay, thanks.
The state have objection to it being marked for purposes of the record,
No, sir.
all right? You may rely upon it.
Where do you presently work?
I work in a private practice, my own practice, Northwest Florida Psychological Services. And that is in Circuit 1, which is in Mariester and Fort Walton Beach area, Florida.
I'm sorry, go ahead. You can finish, please.
I also work for the state of Georgia as a state employee.
And what kinds of psychological work do you perform at Northwest Florida Psychological Service?
When I opened the practice, I had a clinical and forensic practice, meaning I had a certain number of therapy clients. I also do psychological assessments. That's a specialty area of mine from graduate school, where I would do conducting intellectual testing, disability testing, variety of uses of psychometric testing to help make decisions for people trying to get security clearances, for instance, or pre-employment screenings for a variety of agencies, disability evaluations, fitness for duty for law enforcement. Over time, I have reduced my clinical practice. I don't take therapy patients anymore, and I do a variety of forensic evaluations for different purposes. Competency evaluations, meaning is the person understanding enough to proceed to court, sanity at the time of the offense evaluations, provide information about the defendant's background if called to testify in sentencing hearings, for instance. I still do conduct some evaluations for fitness for duty and pre-employment for law enforcement. I'm also a expert witness if needed for Department of Children and Families, Guardian ad litem program. I've been an expert witness for vocational rehabilitation, So I do a variety of forensic work.
And you specifically stated that you work for the state of Georgia. Could you go into what exactly you do for the state of Georgia?
Yes, I am a community forensic evaluator in the state of Georgia. That means that I will go to different jails or offices where people need to have evaluation, and I will conduct competency evaluations and criminal responsibility evaluations. Sometimes I testify in court regarding those topics, and if called, I would be generally called by the state attorney to provide evidence in their case.
So you've been admitted in court as an expert witness in the field of forensic psychology?
Yes.
And someone in your position, can you be hired by either the state or defense?
Yes, either.
In Florida, have you testified in death penalty cases before?
I have, yes.
And in this particular case, you were hired to evaluate Mr. Garcia, is that correct?
Yes.
When did you first start working on this case?
My first meeting with Mr. Garcia was in September 27th, 2019. I believe I received an order just a few days before that. An order allowing me to begin work on the case.
And tell the jury about the records and documents reviewed as part of the evaluation.
I was furnished with jail records, including medications and evaluations that Mr. Garcia has received while in Leon County Detention Center. Also, I received hundreds of pages of records from Mount Sinai Medical Center. That's a local community hospital that he went to. Also, the Department of Juvenile Justice, a case file that included past face sheets, meaning a documentation of past arrests and the outcome of those arrests. Some assessments were included within that.
I'm sorry.
That's okay.
Yeah.
I received a printout of his GED score from his mother. I also had the judgment and sentence of a past arrest that he had in Florida. I have reviewed the probable cause statement for this offense. I believe that's the extent of my record review.
And in addition to that, did you speak to other individuals or third-party contacts as part of your evaluation?
Yes.
Could you tell the jury about that?
Certainly. I had the opportunity to meet Mr. Garcia's mother and interview her and her husband and their residents. During that trip to South Florida to meet different witnesses, I also had the opportunity to meet a childhood friend of Mr. Garcia's named Nelson Nunes. I had telephone interviewing of other childhood friends and adult friends. Ricardo Blankenau was a friend that I interviewed by telephone, and also Michael Fernandez. I also met with Mr. Garcia's employer of 11 years from Coastal Masonry and had an in-person interview of him. I had a telephone interview of his sister Maura to review childhood history.
So what was the result of your evaluation? Could you talk to the jury a little bit about that? Could you describe the important influences on the defendant's early development?
Yes, Mr. Garcia had an unusual early period of his life because of the family stress that he was enduring. Just to kind of paint the scene, when he was very young, his father was incarcerated until he was approximately 5 years old. And that's the first memory that Mr. Garcia has of meeting his father, is when he was being released from prison. He has two older sisters. He has three older sisters, and those sisters were cared for by his mother, who was working as a single mother, trying to raise the children for years on her own. His mother is a very hardworking person, so she would take more than one job at a time, leaving at an early hour before sunup to start working and return after sundown. So that put the burden of some of the childcare on the oldest sister, Mara. When the father was released from incarceration, the parents had a very fractious relationship. Mr. Garcia's father is described as a very handsome man, and therefore many women were interested in him, and he was not faithful to Mr. Garcia's wife. That was an issue of disconnect within the family, meaning that it was a difficult topic that the children were aware of, but Susana Garcia, Mrs. Garcia, was not entirely kept current on that. In other words, Mr. Garcia's father would tell the children, do not tell if I'm going to go see another woman. If you're aware that I'm having an affair, you need to keep quiet or I'll leave. So there was some, I guess, impressing upon them as young children that they're not supposed to speak openly with their mother about these issues. His father also clearly preferred the older sister, Mara. And sometimes when Mr. Garcia's father was actively engaging in criminal activities, he would bring his daughter with him. Because Sigfredo Garcia is the youngest child in the family, he was trying to very clearly bond with his older sister. She was the parental figure that was available to him. She took care of him when his mother was absent. And therefore, Mara felt conflict about exposing him to any kind of criminal activity because he clearly was clingy and wanted to be with her. And she felt conflicted about bringing him to circumstances where he may be exposed to those kinds of topics. So it was a conflict for her. Mara also disclosed that her father was aware that his friends were sexually abusing her and did nothing to stop or prevent that abuse. That became the sexualized behavior, I guess, that was known within the family became an issue because the children, meaning Mara and Mr. Garcia, were sometimes driven to places where Mr. Garcia was engaging in extramarital affairs. And on one occasion, Mara went in to see what was taking Mr. Garcia Sr. so long to come out and drive the children home, and she found him actively having an affair with someone else. The children tried to do their best to follow the rules within the family that Susana Garcia set for them. She kept a very clean house. She had expectations that they engaged in doing their homework and keeping up with school. And it was the overview of what would seem like a normal family life, and that he was attending school and he was doing his homework. And yet there's this dysfunction where the parents are not relating to each other. There's a lot of pain and difficulty. They're residing in the same house, but they're clearly separated. When Mrs. Garcia began learning of the affairs, she was very hurt, obviously. And this overview of pain and resentment and feeling like Mr. Garcia Sr. wasn't doing the right thing by his family permeated the family then, and that continues to be a theme, even in the way that Mr. Garcia feels now, which I will get to in a little while. But that pain is something that was repeated many times in the interviews that I had with his close friends. Not only that, but when Mr. Garcia was about 11 years old, his father was engaged in some kind of criminal activity that required him, or he decided to leave to avoid prosecution or sentence or some kind of wrongdoing. He fled the country and went to Mexico. But unfortunately, when he was about to leave and just abandon his family, he didn't, meet with them or talk to them about it. He just took off. He told the family that he was going to play the lottery, and then he never came back. So Mr. Garcia was very young at that point, and he didn't have a good explanation as to why his father abandoned him and didn't want to be part of his life anymore. And he has been through a lot of different emotions on this topic about feeling abandoned by his father. Sometimes he feels that, is it possible he's responsible in some way that his father didn't want to stay there and be part of the family? The other times he feels just a deep disappointment that his father abandoned his mother and had to burden her with so much work and obligation and raising these children by herself for so many years. But also there's some pain and confusion about why Mr. Garcia Sr. would expose his family, to this lifestyle where he would actively use drugs in front of the children and engage in criminal activities, and just wasn't being the father that the family really needed.
Did the family function differently after Mr. Garcia's father died?
It did because there was no hope of any kind of child support. He was gone. Also, many of the family members had their own emotional problems that started around that time because the father was gone. The older sister disclosed that she started using drugs and was not doing some of the daily activities that she should be doing, like going to school regularly. She sort of, went off in a different direction at that point. And again, that is the family figure that is supposed to be stable and helpful to Mr. Garcia. And though she did her best to look out for him, she wasn't functioning very well herself.
And I believe you touched on this, but could you be a little bit more specific regarding the psychological significance of Mr. Garcia's father leaving the jury?
I think that the departure of his father was the first root of depression for Mr. Garcia, in that he felt abandoned, he felt confused, he felt unloved, he felt unlovable because his father is gone. It also set in motion an unstable family home, and that just made his development that much harder, that he didn't have a stable two-parent home with enough income. The family was impoverished. They were very poor. His older sister said sometimes they didn't have enough food, that the mother couldn't pay her light bill. They didn't have air conditioning because that would cost like $500 to run the air conditioner. In South Florida, it's very hot. So they were suffering. And I think that sense of wanting to be a stable provider as a father and feeling what a father should be has become a very personal issue for Mr. Garcia, about wanting to be a provider, about wanting to be stable, and wanting to be somebody that shows attention and love and care to his own children. So he's had a lifelong arc of effect.
How was Mr. Garcia disciplined as a child? Could you touch on that?
Well, his mother's a strong Cuban woman, and she's direct about, saying that she would call out her children if they were doing anything wrong. She had very high expectations of what they should be doing. Mr. Garcia said that, she would usually just talk very strongly, but on one occasion, she slapped him. His older sister mentioned that as part of, growing up, the discipline did include hitting. There was hitting in the family. And his own mother said that, she became really good at throwing a sandal, which I guess in the Latino culture is a way of punishing, in that she was demonstrating to me how she could aim her sandal just right to hit the kids if they were misbehaving.
Were there any records which describe Mr. Garcia's family functioning that you were able to review?
Yes. So as part of the process of being involved in DJJ, people will write some descriptions of family functioning. And you can see some evidence of what I'm discussing within the write-up that's called a predispositional report for delinquency. It's
Could you tell the jury what DJJ stands for?
Department of Juvenile Justice. So if the child has been engaged, or there's an allegation that the child's engaged in crime, that would activate in that system a network of people to evaluate the situation, to see if there's any room for remediation. And so many people get involved in the case of the onset. In the record that I'm referring to, there's a dated report of June 12th, 1995. And this describes that Mr. Garcia Sr. Has been separated from Mrs. Garcia for 10 years, though they still reside in the same house. Mr. Garcia Sr. has been incarcerated several times. He has little involvement with the family and seems to be indifferent about Sigfredo Jr.'s welfare. His older sister confirmed that in discussing Mr. Garcia Sr.'s approach to Sigfredo Garcia. She said that he seemed to not really try to bond with him. He was the last child. She's not sure if it was because he was a boy that he didn't show affection, but he did seem indifferent to her, clearly focused on her well-being. And Susana Garcia said the same, that there was a focus and a bonding with the older daughter, but they really weren't, Mr. Garcia Sr. just didn't really try with Mr. Garcia Sigfredo.
And the records that you just stated that you reviewed, did they address his academic history at all?
They did describe his current level of schooling at that time. So starting around like the 7th grade or so, and that he was beginning to have academic difficulty. His grades were not good by the 7th grade. Based on the family's description and Mr. Garcia's own self-report, he was a good student prior to that. He is a smart person and he was achieving good grades. But then when he started having these difficulties, he was sent to Jan Man, which is an alternative school. And that just further exposed him to people that are doing the wrong thing. And he was distracted at school, clearly. His friend, Michael, I believe it was Michael, it may have been Ricardo, mentioned that he was in a class for those individuals that might have some kind of emotional handicap or emotional disability. And based on their description of his hyperactivity and high energy, it appears that he was placed in a class that would be for people that might have hyperactivity problems focusing, might need a smaller classroom setting. Once he gets to Jan Man, those services wouldn't be available. It's an alternative school and they've got a different program.
So you mentioned DJJ. Could you explain to the jury your involvement with the DJJ?
At a period of my career, I was working for Bridgeway Center, which is a community mental health center in Fort Walton Beach, Florida. And during my work there, I actually was the program evaluator for the Department of Juvenile Justice. So every region has a doctoral level person who's doing evaluations to see if we can make treatment recommendations once a person gets in trouble, and also to help the state understand if a stricter punishment might be necessary or encouraged, if that might be helpful, to make references to counseling, provide opinions about the severity of the person's difficulties and try to help create some kind of outcome. So I was the program evaluator. And then a different part of my work at Bridgeway Center was to supervise the interns and master's level folks who are writing these types of reports that I'm referencing in the records today.
And in the case of Mr. Garcia, what was his response to DJJ involvement?
He had been sanctioned, as you say, to go into a level 2 program. And a level 2 program is like a least restrictive program. They don't have as many requirements as, say, like a level 8, which would be more like a boot camp type situation, or restrictive confined program. So level 2 was his first referral or recommendation that he had to complete, and he was able to complete that. He was later enrolled in what's called the Dade Marine Institute, which is a school for kids that are having some kind of academic and behavioral problems and may be involved in the DJJ system, though you can voluntarily go there as well. You don't have to be sent there by DJJ. In those settings, what you're trying to do is you're trying to establish some behavioral goals for the person. It could be anything, just depending on what the person's issue is. But like, for instance, school attendance, that might be a good reason to send a child there. And he was able to finish that program, which is remarkable because, they have, these children are there because they have some kind of problem going on, either behavior or attendance. And so completing it is a big deal. He was able to successfully complete that program and the recommendations. And continuing on in the disposition of other cases, it does show that he was referred for other kinds of intervention. For instance, he was sent to counseling as an intervention at Parkway West, which is a psychiatric hospital. He went to counseling and drug abuse treatment, and he was participating in that, and the records reference that he indeed did do that. And he was placed in Bay Point, which is a little bit more of a restrictive program later. And Mr. Garcia described that in a very positive manner. He felt that Bay Point offered the first experience for him of adults setting out a life course of like an achievable goal for him that he could progress to, be productive. And that's what we find in individuals that are missing their father, is that they don't have a goal setting person in their life often to show them how to establish a career, make money, be successful. And that program was very positive for him. You don't often hear that an individual going through a DGJ program actually appreciates the efforts, but he absolutely did. He made progress in his education there. He created a life goal for himself, had some career steps that he planned to take when he got out. His mother describes his behavior as being much improved when he came back. Even though he was always respectful to her, she felt that he was even more helpful. There were young grandchildren in the house at the time. He was exceptionally sweet to them and helpful, and really pulled his weight as a man of the house at that time, even though he was very young.
Can you describe the defendant's early mental health history at all?
So in speaking with people that have known him for his entire life, or most of his life, it becomes evident that he is a person that had very high energy, hyperactivity, a lack of fear. He would do things like jump off buildings, just because he could do that, and it was something that was fun for him. So it does seem that based on the family description and his friend's description of this high energy, and then the placement in the emotional behavioral class, that it's likely he had ADHD. That would be a condition that's attention deficit hyperactivity disorder. His son has elements of ADHD as well, so it does run in the family, and that's common. His other conditions in childhood would be, early on, he was actually a very shy young man, socially anxious. He didn't come out of his shell until he was, working as an adult much later. So early on, unless he knew friends that he had grown up with, he wasn't likely to go and be very open and verbal and communicate. He was actually more reticent and clingy. And so social anxiety was present in youth. He had fears of the dark. He was anxious. He had some feelings of loss and abandonment, as I've already described, that I believe form the root of depression. His irritability is a symptom that would come out at times of feeling confused, lost, angry about his father. And so he had his first onset of major depressive disorder around age 11 with the loss of his father.
Did you learn of any teenage substance use from the records or the people that you interviewed?
Yes, because Susanna Garcia is so occupied and busy working, her children weren't very closely supervised. They had access to substances. They were engaging in substance use in her house. And Mr. Garcia was also exposed to substances because his father was using drugs in front of the children, marijuana, cocaine, things like that. And so in hearing about Mr. Garcia's teenage years, he did begin using marijuana. He would use with his family members. It was something that was available in the neighborhood that he lived in or nearby. So he did engage in substance use. A little bit later, I think it was in his mid-teens, he experimented with a drug called Rufalin, not giving it to others, but ingesting it himself for some just euphoric or mild impairment. And he was
Can
also...
you spell
that? Is that what you're talking about?
Yes.
That last,
Rufalin.
spell that.
I may have misspelled it, Judge, and I apologize,
Okay.
but from my understanding, I think it's Rufalin.
Thank you.
Sure. And he also drank alcohol, but that wasn't his drug of choice. He would drink if it were available, and it's pretty widely available to teenagers.
So marijuana at an early age, Rufinol, alcohol. How about cocaine?
He tried cocaine, but that was more of a drug that he engaged in a little bit later.
And would the use of drugs have an effect on a developing brain, in your opinion?
Well, what we know is that the juvenile brain is at a stage of neurological development where it's very focused on immediate gains and rewards. The dopamine system is enhanced. And so if you have an early exposure to drug use, your receptors will be more apt to crave that substance in your larger development. And so it does change things because experiencing drug use as a form of self-coping for things like painful emotions, you've got a relief from emotional distress, and it changes your pleasure and reward system in a way. It can change your hardwiring.
Let's move on to Mr. Garcia's development. Are you aware of Mr. Garcia obtaining any education after his GED?
Yes, and so what he set out as a course of study is to work on airplanes as a mechanic. He has a love of cars. That's just something that he's always done. And it was one kind of experience that he did have with his father that was pleasurable. So he likes mechanical things. So he enrolled in an aeronautical school. I'll try to find the name of the school. It was part of his overall plan for his future planning. What happened during the schooling, though, is that because he had a past conviction, it's hard to get a security clearance to work on airplanes. You have to pass certain kind of regulations to be able to work on places that people would be repairing aircraft. So, for instance, he might have to work on an airport and not be able to pass the clearance, but he had already invested over a year paying for the school. He had a Pell Grant that he was able to earn because of his grades, but he invested a lot of time and effort only to learn in the career counseling when they're finally beginning to talk about job placement that that's not a career field that he could be employed in. It would be
Baker
easy.
Aviation? You're referring to Baker Aviation?
Yes. And so his hopes that he may be able to perform that kind of work were dashed, even though he'd already committed a lot of time and effort and had a future plan around that. He also around that time was hoping to enroll in any kind of armed forces. He believed in that active service to the country. He wanted to apply to Navy, Army, you name it, Marines. He had a lead on applying to the Coast Guard that they may be able to overlook or suppress or not have to get into his juvenile record, but ultimately that didn't work out. The recruiter was not steady, or something happened to the recruiter and it didn't work out for him.
And how did Mr. Garcia respond to the loss of life direction or future plans?
That had a huge impact on him. He felt like all the factors in the work that he had put in to sort of move forward and make a career path for himself where he could earn money just fell apart. It contributed to a sense of purposelessness, hopelessness, fears of how is he going to support himself. It contributed to a sense of hopelessness in the sense that perhaps he really couldn't plan a future that would be any better than what he experienced as a child, struggling in poverty. And so it really hit home for him. It's very difficult. He was depressed for quite a while.
Did Mr. Garcia describe any other periods of successful career progress?
Yes. And so after he overcame that disappointment, he started doing jobs that he was able to be trained in. He put himself into block masonry training, which is a career that you can get paid by the hour and you can be, effective and efficient. And he had the strength to do that. So he was a good worker. He was able to be employed in both Orlando doing that block masonry, and then also he had a long-term career at Coastal Masonry, working, doing not only block, but he was an operator, meaning he was able to provide working materials that were necessary to get large construction jobs done.
And did he want to be a masonry? I know you said that he was a masonry, but is that something that he wanted to do?
Well, Mr. Garcia felt like really what he wanted to do was get into some kind of oceanography or marine biology. He's got a scientific mind. And so it never completely fulfilled him doing the work, even though he felt pride in doing a good day's work and he worked very hard according to his boss. Walter Kernodle. He was a go-to employee, dependable. He did not call in sick. He was good and efficient, just a really good worker. And yeah, I do think it left a sense of like maybe he hadn't achieved everything he could have. If circumstances had worked out differently for him, I think he'd be in some kind of science field.
As he approached adulthood, did Mr. Garcia have any important romantic relationships?
He did. His first deep attachment was to a woman he knew from childhood. She's from the Latina community. Her name is Elizabeth. And he met Elizabeth or started dating her when he was about 16. And during this period of time, he had started to live outside of his mom's home. So he had sort of pushed towards independence. And he deeply fell in love with Elizabeth. That was his first love. Mm-hmm. That relationship was his first experience in realizing what people being affectionate could feel like. Even though his family was loving, they weren't people that touched very much, like touched one another. And so this was a whole new attachment for him. He was really benefiting from that relationship, and that stands out in his mind as one of his very important love relationships. It also gave him a sense of home because Elizabeth had a good family, and he got to observe how her family interacted, which is very different than how he had been feeling and the roles that his family members played for him. So it was an eye-opener for sure. And then, of course, as you know, he became deeply attached to and involved with Katherine Magbanua. That's a significant relationship in which he calls her his wife. He had 2 children with her, and that relationship began, years ago, and they have had periods where they've been on and off. But that lengthy relationship he describes as the most significant one of his life because of the length of the relationship and how involved they have been.
Could you describe as best you can to the jury the relationship that he had with Katherine? Specifics?
Well, it sort of depends who you ask. So if you ask Mr. Garcia about the relationship, he describes being very smitten with her early on, deeply attracted to her. She's a very beautiful person. He felt that other people at the college she was attending were actively trying to date her. He wanted to date her, and he was, a little jealous of any attention anyone else would share towards her. He definitely decided early on that he wanted to be around her. He told his friend that he's going to marry her. So he knew right away that that was an important person for him. The relationship was sometimes very difficult. It wasn't always entirely pleasant because there was a part of Mr. Garcia that felt he was, trying to please Katherine Magbanua, make her feel like she was important and keep her happy. And yet there were times that she would feel like he wasn't going in the direction she preferred with his job, for instance, or if he wasn't earning enough money, she would point that out. His family went on to describe that there were times that they observed her being so unhappy with him that she would hit him. She would slap him about the face, and he doesn't hit women, so he would stand there and take it. He would be very patient with her. She's extremely unhappy at times in their relationship. And she wasn't affectionate in the way that he craved because of his early life, and not feeling loved and deeply cared for.
Would you say he has a tendency to put her needs above his own?
Clearly, as we heard, in doing the interviews from the friends who mentioned that he would do anything, to keep her happy, especially when they were, having an argument, if he could clean the house to take that off her plate or babysit so she could go out with friends, he would do whatever he could to sort of make her life more comfortable or feel like she's going to be able to, have something that might make her happy. If that going out with friends would ease her mood or make her feel more joyful, he's like, go, I want you to go out. And even though he had worked all day and cleaned and made dinner and, doing all these things, he would still do those kinds of activities to try to take care of her needs.
So they had 2 children, correct?
Yes.
Could you explain to the jury the psychological effects that had on Mr. Garcia having 2 children?
Well, it certainly is. We've already talked about the root of the pain about his father leaving him and abandoning him. He really set out a goal for himself to be a very good father. And all of the people that have watched him interact, including his employer, his friends, describe him as a dedicated father. He would light up when his son would arrive in the truck at the end of the workday. He was there at school functions for them. He was a good provider in the sense that he would make sure that they weren't, struggling for money. He made sure their residence was nice. If the children were going to live there, he wanted to make sure it was a good environment for them. So he did everything that he knew how to do, the template that he had, in trying to be better than his father, to be there for them. And when the couple was struggling and having arguments and whatnot, he would try to. Everyone said they would not have these arguments in front of the children. He tried to separate that and make sure that it just remained between the partners.
So eventually they break up, correct?
A few times, yes. They broke up after the first year of being together, and then they got back together after Mr. Garcia was severely injured. I don't know if we should talk about that right now, but he was shot. So basically what happened to him is he was residing with a roommate named Michael. Michael comes from a really large family, and Michael was raising his own 2 little brothers. And Mr. Garcia moved in with Michael, or they moved in together, and assumed care of these little boys like they were their own, even though they're young men themselves. They're young and they're trying to take care of these boys like their dads. So what happened is Mr. Garcia would take the boys sometimes to school, or sometimes Michael would, or pick them up and bring them home. But this day, the boys had been riding on a bus, and someone approached the boys and tried to ask them to pose in nude photos and pursued them once they got off the bus. They pursued them to the point that the boys came running home into the apartment and said that they felt threatened, that they were chased, that this weird person was going to hurt them. And Mr. Garcia and Michael Fernandez went to go and ask this perpetrator, or possible perpetrator, why he wanted pictures of the children and what his intent was. And when they approached him at a bus stop, unknowingly, the man turned around and fired shots at them both. They were shot up. Mr. Garcia suffered gunshot wounds that were very serious. A bullet entered his lung and his liver. So Mr. Michael Fernandez was also shot. Mr. Garcia pulled Mr. Fernandez across a busy road into a 7-Eleven or convenience store or something and asked for medical help there. And Mr. Fernandez described that they were so close to death that basically their families were notified that they could die. It was like a 15% chance of living. So it was a really serious injury, and it took a long time to recover from that injury. He still had a bullet inside of him. I think the year, I may have misstated the year, it was 2005 when that occurred. And after he started recovering from that, that's when he got back together with Katie, Katherine Magbanua, who offered to help care for him in his convalescence. She offered him an opportunity to come live with her in Orlando. And they lived together there, and that's where their first child was born, Ethan. That was a positive part of their relationship. Mr. Sigfredo Garcia was earning money, and they were doing better. And that continued, that good phase of their relationship continued for a while until they moved back to the Miami area. And then they again started having difficulties after the birth of their daughter, Kaylee. The relationship was not good. It was a very tumultuous time, lots of complaining. I guess, as Mr. Garcia explained it, that they didn't have money. He had injured himself. He had a sciatic nerve go out, or some injury to the sciatic nerve, so he couldn't perform that level of hard physical labor. And because money wasn't coming in, they were having a lot of arguments, and they ended up breaking up around 2013.
If you gotta stop at the point, Mr. Padilla,
Now's a
I
good
need to
point.
give the jury a little break.
Now's a good
Just
point.
be a good start. All right, why don't we take 15 minutes, let the jury step in. You decided anything?
No, sir. You guys need anything?
Didn't need anything. All right.
Garcia found the stranger at 27th Avenue and West Flagler Street, where they got into a scuffle. The older brother clearly felt the need to be a hero, Schwartz said. He and his friend found the man who they underestimated, and they got shot to pieces. Anyone with information, call the Miami-Dade Crime Stoppers.
And that was you just read the narrative to this particular article, correct?
Yes.
Judge McComish?
I thought you were.
Oh, sorry, Judge. I didn't ask the permission.
All right.
This is the actual article that was in there.
It's what she was just reading.
Yeah, she was reading the typed out
Okay.
version of it.
That's fine.
So, Doctor, this is the actual article, correct?
Yes. Correct.
So I believe before we broke, we were discussing the breakups.
Yeah.
Could you explain in more detail the psychological effect that the breakups would have on Mr. Garcia? With Ms. Magbanua?
Yes. So Mr. Garcia experienced feelings of sadness, obviously, with the breakup with the woman that he calls his wife. He felt that his opportunity to build a caring family was destroyed by their breakups, that he couldn't find a way to kind of make the relationship work out. It created feelings of hopelessness for him. He also felt that she was using the children as a method to influence him, basically withholding them. He couldn't see them. And so his inability to access the children and see them as much as he was used to made him extremely sad and stressed, anxious, angry, all of the above. He disclosed those feelings to his friend Ricardo. He started spending a lot of time with him, expressing how seriously sad he'd become over the breakup, that he was experiencing depression. Ricardo had recently underwent a divorce or was divorcing, so they bonded over that issue, that he was very sad, and it's difficult to get a new pattern in your life started when you're used to the old familiar person, even if that person isn't necessarily always good for you. And Mr. Garcia just still, kept mentally referring back in his mind to that relationship. I think that he had some difficulty letting go. Most of the people I talked to would describe it, they seemed to flock together. They would break up, but there would be text messages sent. And his sister Mara mentioned that, if Katie had broken up with him, she would be texting him immediately, quickly, within, just a short amount of time. And so there seemed to be push-pull. It was very confusing, and he was struggling.
Would you describe Katherine as being substantially dominant over Mr. Garcia?
Yes, because she would threaten to take the children and move to the Philippines with them as a way to not let him see them permanently. Also, as time went on and he did join a new relationship, she would prevent them from having the kids. She wasn't allowing them, to go back and forth, like a parenting co-parenting situation. So she was controlling about their whereabouts, and she would express things about needing money for their care, even though Mr. Garcia was providing her with money. As his sister described, it was never enough. She would ask for money, and so it was difficult for him. He felt not good enough. He felt sad about the loss of the relationship. He felt that it was a repeat of his father abandoning him, and lots of loss, confusion, and sadness about that.
And her withholding the children, if she didn't get what she wanted, was that an isolated incident, or was that something that in your evaluation came up on?
That was information that was provided by his sister, who had, was there with him in times that he was recovering from the breakup. Because of his depression, he would sometimes self-medicate with alcohol and start drinking out of sadness. And so he would go to his sister's house and use substances to sort of clear his mind. And so she would see that pattern where there would be communications of, threatening to withhold the children and not return the children to him.
May I approach it?
You may.
Doctor, I'm showing you what's been marked as composite, exhibit 7A through 7K. Could you look at that? And explain to me what the document, those documents are, those images are?
These are photos of people that are Mr. Garcia's family members, people that love him, people that he's had relationships with.
How were those pictures provided to you?
His mother, Susana Garcia, had family photos when I went to her residence, and also his sister provided family photos as part of our interview with her.
And are they in the same or substantially same condition as when provided to you?
Yes.
Judge, I'd like to move these into evidence at this moment.
What is the number? I'm sorry.
7A through 7K.
This is the one we discussed at sidebar.
Yes, Judge.
All right. Subject to my prior ruling, I'll admit 7A through K.
Talk to the jury about this.
So that's a picture of Susana Garcia and Mr. Garcia when he was a young man. He's just a baby, a few months old in that photo. So this is a later photo of Sigfredo Garcia and his mother. He was obviously is a very tall individual for a young age, so even though he looks older there, he's actually juvenile. That's one of the family photos that Susana provided. That's a picture of Mr. Garcia Sr. She described him, as a handsome person that a lot of people wanted to have relationships with. And so that's an earlier, younger year photo before Mr. Garcia Sr. left. Yes, this is the older sister, Mara Garcia, that I testified about previously. Sigfredo has a very close relationship with her, and they've been, close sibling bondedness. They've had that throughout their life. Those are his mother's sister's children, and so they're extended family cousins. He actually was very helpful. Anytime there's children involved in the family, he's been a person who's been, apt to play with them and interact with them. And so these two cousins are also, close relatives of him. That's Manny and Gabby. sort of speaks for itself. It's Mr. Garcia when he was younger, and you can see, that he physically developed at a pretty young age. He looked older. That's during the period of time where Mr. Garcia lived in Orlando with Ms. Magbanua, and they're expecting their first child. So this picture has a photo of several of Mr. Garcia's friends that I've testified about already. To the far right, we have Michael Fernandez. Second from the right, we've got Ricardo. We've got Mr. Garcia, and then a friend named Red. And Mr. Fernandez and Ricardo both described that they were very close, and they would raise their children and together and kind of just like bond and overlap about being fathers. And that's after the birth of Ethan. So that's Mr. Garcia and Ms. Magbanua and their son Ethan. And that's a photo of extended family. So Mr. Garcia was very close to Katherine Magbanua's mother. He thought of her as his mother-in-law. She passed away from cancer after he was incarcerated, but that's a photo of them all together before.
So, Doctor, back to the relationship between Katherine and Mr. Garcia. Besides withholding the children, what other examples did you see of substantial domination that she had over him in a relationship?
Well, I think that she knew she could say things to him that would be most hurtful. So some of the things that she communicated that his sister overheard would be, "You're a terrible father. You're not going to amount to anything." So she would say emotionally harmful things that would touch at the spots where he already had, emotional issues about those particular things. If he told her no about something, Mara described that she would continue to ask, and eventually he would relent to do, if she wanted to go out, for instance, and he had work conflict, eventually her needs would be met.
And during these multiple breakups, was Mr. Garcia the one that always wanted to get back together with her?
It seems so. I don't think that he ever stopped thinking about her or caring about her. And so he would choose to leave after they had conflict, but he would also choose to return to the relationship.
Leading up to the offense, would you say that the defendant has any psychological symptoms?
Yes. So during the time frame in which the offense occurred, this is during a period where they were broken up. Mr. Garcia had been injured, and he had a sciatic nerve damage or injury that would require a lot of rest, and he wasn't able to work at the speed and the pace and precision that he used to, so he wasn't earning income. And during that period of time, Katie was described as, wanting him to be a better provider, and he didn't have a lot of money coming in. So they separated at that time with a lot of conflict, and he was not doing well psychologically. He was experiencing depression. He felt embarrassed about his, reduced financial resources. He didn't have a set residence because he was trying to give them money to maintain their residence. So there were periods of time that he lived in a campground or borrowed a couch to sleep on at somebody's house. He was feeling hopeless, like the relationship had really ended and there was no chance of reconciliation, that she was going to prevent them from getting back together again. He was, at times, as his sister describes it, laying in the bed, looking at the wall, not even really like interacting. He had withdrawn into depression significantly. She had told him he really needs to seek help. She's trying to encourage him to try to talk to someone about this depression. So he was experiencing another episode of major depressive disorder at that time. He didn't really care that much if he lived or died because his value and his self-worth was tied to working. He takes a lot of pride in being a good worker, and he couldn't work. And he also takes a lot of pride in being a father, and yet he was prevented access to his children often. And he also felt, the loss of being a good husband or mate, and felt the relationship had ended. So that was an episode of depression that he was experiencing at the time.
Could you talk to the jurors about what the DSM-5 is?
The DSM-5 is what classification system psychologists use to make a diagnosis. It contains criterion in which you can consider for diagnosis. It will help explain what normal facets of a disorder are, because it can vary presentation. Depression in a man might look different than depression in a woman, or based on the cause. So it lays out criterion that we can reference to come up with a diagnosis.
And is that something they use in this case?
Yes.
Did you see specific evidence of PTSD as related to when he got shot? Could you talk to the jury about that?
Yes. And so an additional diagnosis that Mr. Garcia has is a complex anxiety disorder, meaning it's not just like a easy one generalized anxiety disorder. He's got 3 types of anxiety that have been present in his life. I already mentioned to you about the social anxiety that occurred earlier in his life. The secondary kind of anxiety that was described both by self-report by Mr. Garcia, but also his friend who was shot at the same time. They've talked about that significant experience several times over the last few years since they went through that together. Both of the men had an unusual reaction. About a month or so before he was arrested, they were outside hanging out, I guess, talking, and a car backfired and they both hit the ground. So they have that instinctive reaction where the body creates an involuntary response to loud noises like that, felt unsafe, sense of safety is impaired. Mr. Garcia explains that it's very anxiety provoking if people come up behind him, that feeling that something bad is about to happen, a sense of unknowing about his safety. Also, if movies come on that contain a lot of violence and gunshots and things like that, it's so distressing to him, he will get up and leave. If it's presented like in the jail as an example, or movies are playing, that's not something that's comfortable for him because it will generate nightmares after he sees it. And so he would choose not to have that kind of exposure.
Does Mr. Garcia have a personality disorder?
He does not have a personality disorder. A personality disorder would be an impaired, long-standing inability to relate to others. In stories that I spoke to of people that have known him for a very long time, they mention that he's easygoing. He's not somebody that's going to get into arguments. His employer, Walter Kernodle, would actually have Mr. Garcia interact with vendors that they needed for construction because he had a calm temperament. In a construction site, there's a lot of hot tempers running. But he would be able to interact with the people that might be holding up the job and keep a level head. His friends describe him as a loving, caring person who would do anything for anyone. In terms of if they didn't have a shirt, he would give them a shirt. If they didn't have 15 cents, he'd give them money, that kind of thing. That he's always thinking about how to help someone else with whatever their problems were. He was, sometimes to his detriment, apparently, according to one of the witnesses I talked to, Nelson. Mr. Garcia loved cars, so he had cars and he would loan them out to people that were falling on tough times and then not get them back. Sometimes these people just keep his property, and Nelson would ask him, where's your car? Why don't you go and get your car back? And he's like, oh, they're having a hard time. They need it more than I do at the moment. So he has a caring disposition. He cares about people. He has, acts of kindness and caring and tenderness that would not suggest the presence of a personality disorder.
How would having a mood disorder affect his behavior?
So the mood disorder means the depression and the anxiety disorder, and that means that in times of stress, he may experience some interference in like quickly, efficiently getting up for the day, as an example. He might have more difficulty making a rational decision. He had emotional based decisions based on some of the friends describing, you know, that he's trying to take care of other people, or that he's so wrapped up in thinking about Katie that he's not like taking care of his own needs as well. So he had some emotional responding. But I also think that the mood disorder was a basis and underlying reason that he would self-medicate a lot. He started drinking more heavily over, you know, the last period before incarceration. You know, going through the depression, that's one of the times that after the breakup, his sister noticed an increase in using alcohol. He kept alcohol on his desk at work that his friend who worked with him was aware of. And so I do think that it was a coping mechanism to drown out some of these feelings that he had so that he just didn't have to experience them. He's really not comfortable showing that because he feels depression is a sense of weakness. And that's not a comfortable position for someone that's a Latino man to go around and talk about, you know, hard times, or that they feel like, you know, too much expression of their own pain. It's not manly to do that. And so I think he would drown those feelings out.
We've heard a testimony about depression, anxiety, and substance abuse issues. Does that mean that he cannot be rehabilitated?
No, actually, those are treatable conditions. At one point in the jail, he was on an antidepressant, and that's a good treatment. With anxiety and depression combined, physicians will often use a low-dose antidepressant, and that will effectively combat the anxiety. It's something that's fairly easily accessed. Like if you were out and about, you could get your general physician to treat you with that. And he has, you know, had counseling in the past. He could have counseling in the future. I think that working through these feelings of loss with his relationship and the conflictual relationship he had with Ms. Magbanua, I do think counseling was a good recommendation for him, and those would be my recommendations.
You've described his desire to help others and follow a plan for guidance. Would that affect his ability to be successfully in prison?
Yeah, I do think so, because I think that in times where structure is offered, it creates reduced anxiety for him. I think he has a desire to comply. You know, he's a friendly person. I think that, you know, he doesn't have you know, extreme lengthy history of getting into trouble in the jail. He has had you know, a lengthy period of time waiting trial, and he's done well enough, in my opinion. He had one instance where somebody approached him rapidly in the jail as if to strike on him, and that person was described as having aggressive speaking, was intimidating, and had ultimately, I guess, some mental health conditions. And Mr. Garcia did, I guess, protect himself in that sense. He felt threatened by the person that was approaching him rapidly like that. And so he had a DR. It's not a charge. It's like a write-up that occurs in the jail when somebody, you know, is not falling in line, or they have some kind of instance of difficulty, and they can have a punishment like remove them to a quiet cell or things like that. And so that's the extent of it. He's been, you know, for months and months at the prison in general population.
And that's the only instance that you've heard of? Of any type of alleged violence or anything from Mr. Garcia while his time here in Leon County incarcerated?
Yes.
Can I have a moment, Judge?
You may.
Further, Judge.
Cross.
Dr. Harper, how many death penalty cases have you been involved in the state of Florida?
I have been an expert about 16 times in the state of Florida.
Okay. And how many of those do you testify about equally for the state and defense?
For death penalty cases in Florida, I have not testified for the state yet.
So they're all for the defense, 16?
No, most death penalty cases don't go forward into a trial setting. I've testified, this would be my 7th time testifying in a death penalty case.
Okay, and it's your 7th time testifying for the defense in death penalty cases in Florida?
That's correct.
All right. And your diagnoses in this case, I want to kind of jump right into those. Did you diagnose Mr. Garcia with major depression?
I did.
All right. And did he have any history of being diagnosed with that previously before your diagnosis?
Yes.
When was that?
He had a diagnosis of depression from the jail.
Okay, so since he's been in jail in this case.
Yes.
Would you agree that being incarcerated lends itself to depression?
I would find that's common.
All right, particularly in a very serious case like this where you're facing potentially the death penalty or life in prison. Would you agree that would exacerbate the depression?
Yes.
All right. But prior to that, no evidence in his records of a diagnosis of major depression. Would you agree with that?
Not in the records.
Okay. And you talked about how at age 11 he had this depressive episode when his dad left the home. Can you tell us a little more clearly exactly how much exposure Mr. Garcia had to his father? Because it seemed like he was incarcerated for a large portion of Mr. Garcia's life. Could you just give us that timeline?
Sure. So from Mr. Garcia's recollection of first meeting his father, it was age 5. If he was around him earlier than that, Mr. Garcia doesn't have intact memory of that. So his recollection is meeting him when he was released from incarceration at around age 5. And then he was present in the home. And Mr. Garcia described that around age 11, he departed or was on the run.
Okay, so the dad was around between ages 5 and 11 for Mr. Garcia?
Yes.
Okay. Did you also diagnose Mr. Garcia with PTSD?
I did.
And that's from the being shot incident?
In 2005, yes, he was shot.
And is that a condition that has resolved itself or that he's currently suffering from?
So I do feel he still has that condition. When you have post-traumatic stress disorder, you're going to see it in times where it was triggered. For instance, if you go through an entire day and don't have anything that reminds you of the circumstance of your near-death experience, or you're not seeing something on TV or reading about it, it may not be activated that day, but it doesn't mean that you don't have the diagnosis.
All right. And would you agree that carrying and shooting a firearm could potentially activate that diagnosis?
Well, I mean, that's a hypothetical, so who's to say?
Not really. That's what's alleged to have occurred in this case.
So if I'm referencing the way that you're phrasing the question, an individual with post-traumatic stress disorder who has already been described as having reactions to noise and gunshot, which wasn't the case, it was a car backfire, and experienced distress over that loud noise, then yes, you could have an exacerbation of trauma symptoms.
Okay, and wouldn't it be more consistent for a person who is suffering from this type of post-traumatic stress disorder to avoid things like carrying and discharging a firearm if that's a triggering event?
Yes, I would say that would probably be fair. Though I work with people exiting the military all the time who have those known exposures to, live fire, police officers who are responding, in a fitness for duty evaluation. You can still, have contact with things that are triggers, and you just have to manage them on the inside.
Okay. So then if he was able to manage the symptoms and still handle and discharge firearms, what relevance does the PTSD have on the case that this jury is considering?
Well, the interesting thing about mitigation is that a person's life history and the things that they went through are important factors for the jury to consider, and they don't have to be specific to the case. PTSD in this circumstance is very important because he has an anxiety disorder that I feel like creates distress for him in a lot of situations. It also is something that's in need of treatment. It also contributes to his sense of kind of general distress, and it's been a lifelong problem since he almost died.
Okay, but that's not a diagnosis that specifically relates to the facts of this case necessarily.
I don't think that it has to. As far as I'm aware, a diagnosis is part of his life history.
Okay. Complex anxiety disorder, is that something that you diagnosed?
I described his anxiety disorder as a complex anxiety disorder.
Is that a diagnosis in the DSM manual that you previously referenced?
No, it's a way to describe when a person has multiple kinds of anxiety.
Okay. And what is the basis for your, can I still call it a diagnosis?
Anxiety disorder is a diagnosis.
Okay. What's the basis for your diagnosis of that?
So the report of his friend who has witnessed traumatic responding, that would form a basis for that third-party observation. And his friend's description of him, having suffered and gone through that difficult time so that he couldn't function easily, had physical recovery to take over. So it would be a change in loss of prior functioning. Also, Mr. Garcia described symptoms of post-traumatic stress disorder to me and some obsessive compulsive tendencies, which his mother also has. And also the description from Mr. Garcia early on about having been so shy, the social anxiety that was present in youth.
Okay. Was he ever diagnosed with anxiety disorder previously before you diagnosed him as such?
He was treated with diazepam at the hospital, which is an anxiety treatment.
Okay, and when was that? What hospitalization?
That is Mount Sinai records, and that was from 2013.
Okay, and don't those records indicate that while it is a antidepressant medication, in this case, it's being prescribed for back pain?
So it's an anti-anxiety medication, and it can also have a muscle relaxant property, and muscle stiffness, tension is a symptom of anxiety.
Okay, but in the records that you're referencing from Mount Sinai, the complaint was back pain, and he was prescribed diazepam for that pain.
I believe at that time, yes, he wasn't prescribed for back pain. It said for muscle tension.
Okay, he wasn't reporting a back injury from working in construction?
He was.
Okay. And was he diagnosed at that time or any time to your knowledge with this anxiety disorder?
I didn't find his ultimate diagnosis in that record.
All right, so when did you diagnose him with anxiety disorder?
During the course of our evaluation together.
When was that? Can you give us a
Sure.
date?
So I saw him on 9/27/19, 10/4/19, and 10/13/19.
Okay, about how much time did you spend with him overall?
8.5 hours.
Okay. All in 2019?
Yes.
Okay. I want to ask you about the ADHD diagnosis. Was that another one of your diagnoses of Mr. Garcia?
I found symptoms were present in childhood. Yes, so I would say it was a childhood diagnosis.
Okay, and does he suffer from that currently, in your opinion?
I would probably say that it is largely resolved. He didn't report a lot of present symptoms of that.
All right. And you talked about his time at the Parkway West facility.
Yes.
And that was about when he was about 15 years of age. Is that right?
I think that's correct.
Okay. And you mentioned that's a psychiatric hospital, but it's also a substance abuse treatment center, correct?
It's reference in the records that he was receiving counseling,
Mhm.
substance abuse treatment, and schooling there.
Okay, so difficult to tell whether that was for psychiatric issues versus substance abuse issues. Would you agree with that?
No,
So you can tell the jury that it was for one or the other or both?
as listed in the record, counseling and substance abuse treatment, that would suggest that those are separate.
Okay. And was that court-ordered treatment that he received there?
I believe so.
28 days at that place?
Yes.
All right, and that was after he got caught with some drugs, correct?
I'm not certain what the charge was at the
Right,
time.
he was stealing a car and he got arrested and he had some drugs on him. Sound familiar?
I would agree.
Okay, so substance abuse would probably seem like an appropriate court-ordered treatment for that type of offense. Would you agree?
Yes.
All right. And you mentioned that the DJJ program, that 28 days at Parkway West, was a successful. I may be putting words in your mouth. I'm sorry if I am, but didn't you say it was that was helpful to him, or he was successful there?
No, I did not see.
Okay, but actually he was not compliant with that program and was kicked out, right?
The program I was referencing is Bay Point, and I think the program you may have been referring to is Floyd House.
Parkway West is what I was referring to. The
Mm,
28-day treatment program after the arrest with the drugs.
Okay, I saw records that he was participating in Parkway West.
Would it refresh your recollection if I show you exactly what record I'm referring to?
Sure.
All right, doctor, this is the document I was referencing. Take a moment just to see if that's familiar and look that over.
Okay.
Are you familiar with that record?
If it was contained within, I don't specifically recall it, but I will defer to you if it's part of the DJJ packet that was provided.
Okay, so basically what I was getting at is that he was non-compliant with the program rules there and was ultimately kicked out.
It said that he had increasing difficulties while in the program.
Okay. Would you agree that children diagnosed with ADHD or with symptoms of ADHD are more likely to be diagnosed later with antisocial personality disorder?
So the interesting thing about antisocial personality disorder is there's about 288 different precursor diagnoses that could make you arrive there.
Is that
ADHD
one of them?
Yes.
All right. And Mr. Garcia, does he have antisocial personality disorder?
He does not.
All right. What is antisocial personality disorder?
So antisocial personality disorder from the diagnostic manual is a personality disorder that indicates that the person does not have empathy for others, that has an ability to put their unusual amount of empathy and experience what it feels like to be in someone else's shoes.
All right. Would you mind pointing to me where in the DSM it indicates that empathy is part of the criteria for antisocial personality disorder?
Okay. So it's in the diagnostic features section on page 660. Persons with this disorder disregard the wishes, rights, or feelings of others. And
all right. What's the difference between the diagnostic features versus the diagnostic criteria that's listed up above there?
So the diagnostic criteria are a summary of the way that you can diagnose the disorder. The diagnostic features help to distinguish and identify aspects of the disorder in more detail, so that if you're not sure and you can consider factors one way or the other, it gives you a better explanation.
Okay, so let's go back up to the kind of what's the main test before you go on to read in more detail the distinguishing factors. So the first
Objection, Judge, this is outside the scope.
Overruled.
The first criteria for antisocial personality disorder is failure to conform to social norms and respect lawful behaviors, correct?
Yes,
All right, so basically violating the law.
correct.
And would you agree that that's a problem for Mr. Garcia?
I think that you could say that. He's been arrested. So any person that's in a prison situation or in a jail could have that criterion.
How many times has he been arrested?
As an adult, I think he had a few drug charges and a prior felony. So
Okay. And what about as a child?
would you like me to count? Because some of those were nil pros, so I'm not exactly
That's okay.
sure.
Can we agree he's been arrested more than 10 times in his life?
I think that's fair.
Would you agree that the first time he was ever arrested was 6 years of age?
There was an early, there was an early contact with police.
How unusual is that for a 6-year-old to be subject to an arrest?
I think they just had something in the newspaper recently about that, so it's not completely out of the ordinary, unfortunately.
But it's pretty unusual, as evidenced by the fact that it makes the newspaper when it happens. Would you agree?
I'd say it's less usual than, say, a later teenager. Sure. And it's because you have to try to figure out how to address the person's developmental needs in a setting that's geared towards teenagers. And you can't house a 6-year-old in a detention setting. So it makes a lot of confusion as to, what you can do to help point that person in a rehabilitative setting. So looking at the family, a lot of times you'll get social workers involved.
Sure, but the point is Mr. Garcia got arrested when he was 6 years old, and he's been arrested at least 9 additional times since then.
If that's your point. I don't know, is there a question there?
That's my point.
Okay.
Would you agree? And that is the number one feature criteria for antisocial personality disorder.
So if you please rephrase your question, what are you asking me?
So he meets the number one criteria for diagnostic.
Yes, as almost any person in a jail setting.
Okay. And what about gang membership? Is that something you would consider for that first criteria, failure to conform with social norms?
In what case?
In any case.
So in Mr. Garcia's case, he's not part of a gang.
Okay, has he ever been part of a criminal street gang?
No.
You're not aware of that? So no?
No.
Okay. And what about conduct disorder? I guess that's kind of maybe repetitive of what I was saying. Is conduct disorder the same thing as saying he's been arrested a lot?
Well, in youth, it's a little different. You can only diagnose conduct disorder in people that are younger than 18, and it depends on the circumstances. So conduct disorder is one of those that has a similar criterion where you've had difficulty maintaining social norms, for instance. So depending on what's going on in that juvenile's life, is there a failure of support, of guidance? It would depend why the person has been labeled with conduct disorder and what their personal history and circumstances are to determine if that might be associated with antisocial personality disorder.
Okay, well, we're talking about Mr. Garcia. So does he have conduct disorder?
No.
All right. And the arrest at 6 years of age wouldn't qualify him for conduct disorder?
I would say no.
The setting a building on fire in 1994, that wouldn't qualify him?
A single event is not going to qualify someone for conduct disorder.
Sure,
That would be a misreading of the diagnostic criteria in the sense that you have to consider what other influences might be present in a person's life that would, lead him. For instance, the Supreme Court allows us to consider the influence of peers as an important factor in culpability and criminal responsibility. So you have to consider the situation that the person is in as to why they may be engaging in that kind of behavior.
Okay. So you wouldn't consider those not single incidents, but multiple incidences of criminal behavior to qualify this defendant for conduct disorder?
I wouldn't, because no DJJ officer suggested he had conduct disorder, and they had multiple contacts with him.
All right. They also didn't suggest that he had major depressive disorder, ADHD, or complex anxiety, did they?
They did not, but the people that have known him since childhood did feel that.
Okay. And you mentioned at least one physical fight, I think, in the jail. Were there other physical altercations that you looked at as you went through his records history?
There were some reference in the medical records that he had been assaulted by police. They broke his orbital bones around his face.
Okay. And then he had the physical interaction with the pedophile guy.
He had a verbal altercation with that gentleman,
Okay.
and that man shot him out of the blue, unexpected.
Okay. And then there were some other physical altercations as well in his criminal history from the juvenile records. Would you
Yes.
agree with that? Okay. And physical fights, that is another feature of antisocial personality disorder, is it not?
Well, if you consider that as protectiveness or disregard for the rights of others, you could see it that way.
Okay. What about reckless disregard for one's safety? Is that considered a diagnostic feature of antisocial personality?
It could be.
Okay. And does Mr. Garcia exhibit that feature?
Not currently, no. There
Okay.
are times because of depression, he didn't really care if he lived or died, but that's because of a psychological mood disorder, not antisocial personality disorder.
Okay. So the two motorcycle accidents, those wouldn't qualify as disregard for safety, even though he was traveling at least on one occasion over 100 miles an hour when the vehicle wrecked.
He didn't care if he lived or died.
Okay. And he was described as a daredevil in childhood. Is that something you noted?
He was described as having no fear. He would do a variety of things that just to see, if he could jump off that second story roof or something with a bunch of kids. It wasn't just him.
Okay.
They jumped off the bridges together.
Sounds like a daredevil.
Well, they all were, I guess.
Okay. Irresponsibility, is that one of the diagnostic features?
It is.
Impulsivity, is that one?
Yes.
Okay. Any indications regarding his IQ? Was that something you looked into?
The only thing I'm aware of regarding IQ is that it was referenced somewhere in the DJJ records that an IQ test had been performed in youth, and it was in the average range.
Okay, so no issues with his IQ.
I would not say so.
All right. And that's consistent with his acceptance to the aeronautical school. Would you agree with that?
Sure.
All right. I want to go on to talk a little bit more about the absence of his father in his life. His dad was a criminal influence, correct?
Yes.
So is it a good thing or a bad thing that he didn't have a lot of exposure to his dad?
Well, I think that his sister indicated that she had concern about prolonged exposure. She tried to be a better influence or try to keep him away from his father.
Mm-hmm.
So the thing is, as a child, you idealize your parents, good or bad. And so the idea that his father was a bad person or doing bad things, that wouldn't be the way that he would see it. He would have feeling that there's an absence or loss or rejection, and probably without the forethought or the ability to kind of weigh out, is this a good person? Or, are they steering me in the right direction? He didn't realize that till much later.
But he may have been better off in hindsight without the dad in his life.
That's a judgment call. It's hard to say.
Okay. Well, dad influenced him to break into cars.
That's correct.
Dad used cannabis with him.
Yes.
He stole cocaine and used dad's cocaine.
Yes.
What about the maternal grandfather? Was he in the home? Are you aware of that?
So what I know of the maternal grandfather is that Susanna's father was a person who was excessively working. He was one of those people that had a lot of things to go through, psychological things to overcome, but he was very much like a workaholic.
Did he live in the home with Mr. Garcia?
I'm not really sure. I believe there was a period of time that Mr. Garcia and his older sister lived with the maternal grandmother, but I'm not sure if the grandfather was present at that time. I just don't know.
Okay. And what about the stepdad? You said there was a stepdad present in Mr. Garcia's life. When did he come into Mr. Garcia's life?
I believe maybe when he was around 15.
Okay. And is still present?
He is.
Okay. And by all indications, he's a decent guy and a good influence?
Yes,
All right. And mom loves her son?
of course.
Sisters love him?
Of course.
Okay. Were his basic needs met during his childhood?
Somewhat.
Okay.
He had many times where they didn't have electricity because of the cost of the bill. His sister described that they were so poor that food was an issue. And basic needs for love and someone to affectionately care for you, I don't think that that was consistent for him at a young age.
Okay. So even from mom and sisters and stepdad, he wasn't getting enough affection.
Yes.
All right. And you mentioned hitting, that mom was hitting him, but then you went on to describe something that sounded more like discipline or spanking. Do you know which it was? Because hitting sort of implies abuse to me.
Correct. And it depends who you ask. So according to mom, she would discipline any of the children by throwing her sandal or, verbally just going over the rules. She said she's a strong Cuban lady. His sister described that, yes, indeed, they were struck when they were children. So I have two different reports about it.
Okay. And the sisters, do they have legal troubles as well?
I don't know.
You mentioned that Mr. Garcia is a dedicated father and wanted to do better than his father did for him. But he used drugs like his dad did, right?
Yes, he did.
And committed crimes, same as his dad.
Yes.
And ended up incarcerated like his dad.
That's correct.
All right. Do you agree that his choices negatively affected his children?
Well, I haven't psychologically evaluated his children, so it's hard to say if the protective factors sort of weigh that out. I think that Mr. Garcia is very concerned that some of those choices have impacted his children.
Yeah, and I think you just made an argument that, from a child's perspective, losing a dad is going to be a negative impact no matter what kind of dad he was,
It could
right?
be. Yes, it could be.
All right. And would you agree that his choices have negatively affected Mr. Markel's children?
Yes.
Right.
If, as the jury found.
Right. Let's talk about Ms. Magbanua being domineering. How does that relate to the facts of this case, this murder?
It goes to his state of mind and what kind of influences were present at the time in question. So his feelings that he needed to please her or to try to fix things with her, I think that was a preoccupation of his.
All right, but was he asked by her to do this murder?
I don't have that information. Not that I'm aware of.
Do you have some kind of opinion as to whether or not he'd be willing to do a murder for Ms. Magbanua if she asked him?
Overruled. She's
Is that
opinion.
Yeah, is that part of your opinion?
I don't think I can offer that opinion. It's not consistent with his history. He doesn't have a history of murder. So if you go on past behavior.
Okay, but he does have a history of doing unlawful things while under the influence of some other people. I think you kind of alluded to that. Did you?
Unlawful things like breaking into cars.
Okay. And robbery?
Well, the robbery is an interesting situation in the sense that he was kind of last on the scene in a strong arm robbery, and he did have a charge of robbery, but he had a co-defendant who ended up being sentenced for that crime, and he had a 1-day in jail sentence.
Okay.
So
it was the co-defendant's fault primarily.
It would seem if he had an 8-year sentence and Mr. Garcia had a 1-day sentence.
And that's kind of where I'm going with this. Is it the co-defendant's fault primarily in this case too?
I think that you're asking me to speak as if I've sat through the whole trial about it. I think the jury has made a decision about that culpability. My job is really explaining his state of mind.
Okay, but the defense includes that Mr. Garcia was an accomplice in the first-degree murder committed by another person and his participation was relatively minor. Is that something that you're prepared to offer an opinion on?
No.
You mentioned his need to work and that his depression was somewhat tied to his inability to work, or he wasn't working at the time that he became depressed the second time. Is that right?
I don't know if that was the second time, but that was part of an episode of depression, yes.
Okay, my understanding was the first time was when Dad left, and then the second major event was when he broke up with Ms. Magbanua, or she broke up with him.
No, he had a loss of sort of his future career progress, and that was an instance of depression when he couldn't do what it is that he was hoping would be kind of his life direction that he had planned within the DJJ program as a career track. So that was the second. And then there was a breakup with his girlfriend, Elizabeth. That was another instance of depression. There was a fourth instance of depression when he felt like it was the final breakup with Ms. Magbanua.
Okay, and is that final one that you tied to inability or unwillingness to work?
I never said unwillingness to work, because that would not be characteristic of Mr. Garcia.
Okay.
Inability to work because of his medical problem, causing him to not be able to lift his blocks, or as he described it, like 40 or 50 pounds, and he would throw them up a staircase every day. So he couldn't do that with the physical injury that he had.
Okay, so are you familiar with his work history between 2009 and 2014?
I did interview Mr. Kernodle, about his work history during that period of time. And then Mr. Garcia also provided some examples of places that he had tried to have employment.
All right, and that's the coastal masonry guy, the
Yes.
Kernodle guy. Okay. And did you learn that, and you did learn also that he was employed at this rapid capital funding between 2015 and 2016?
Yes, more recently.
Okay, so looking at the time period between 2009 and 2016, would you agree that his employment in general was sparse and sporadic?
No.
Okay, so you would not agree that he was only employed for about 27 months over that 6-year period?
No, according to Mr. Kernodle, he was off because of an injury, and any time that he would have work available for him, he would work.
Okay, but he only did work 27 months.
Objection, has been answered.
Overruled.
I'm not sure where you're getting that information.
Okay, well, I'm looking
not-
at his financial records. Did you have an opportunity to review his financial records
No.
to see what dates he was paid for working?
No, I don't have that
Okay.
information.
You mentioned his depression associated with the breakup with Ms. Magbanua. Are you aware of any diagnosis, treatment, or medication associated with that particular bout of depression?
His sister urged him to go, but he did not.
All right, and you talked about his good behavior in jail and said he only had one physical altercation in jail. Do you recall that portion of your direct examination?
Yes.
Okay, he also had some DRs for some other things though, right?
I think his co-defendant had some kind of candy. They're making some, or not they, but there was some allegation that they were making
His
jail.
co-defendant?
Or not co-defendant, sorry, his bunkmate.
Bunkmate,
apologize.
okay. And they were making some alcohol in there, right?
Yes,
Okay.
called something else like hooch or something.
All right, bunk.
Mhm.
thing.
Something.
I don't know. I might be making that up. I think it's what it is. All right, one moment, please, Your Honor.
You bet.
No further questions.
Redirect.
Doctor, Ms. Kappelman asked you about if you had reviewed financial records for an extended period of time. Are you aware whether or not the work that Mr. Garcia was doing is work that is properly paid for cash?
I understand that some construction jobs, excuse me, are paid in cash rather than on the record or to earn tax credit.
Now, you described on direct when Mr. Garcia, early on in life, when he was young, 5 and 6, having multiple issues that are not available to normal children. Is being arrested consistent with a child that's suffering psychological issues or poor family issues?
Yes, clearly.
We, Ms. Cattleman spoke a lot about antisocial personality disorder and the criteria, and I think you gave a number of, there's a lot of criteria for antisocial?
The features of the disorder are described in more detail. You have criterion, but the features include ways that you must consider alternative explanations. Meaning, if the person has symptoms or evidence of other kinds of disorders that would better explain that, then you must diagnose that. So for instance, if the symptoms could be explained by irritability due to depression or impulsivity due to ADHD, then you wouldn't diagnose a personality disorder, because it's a catch-all term essentially for criterion that many kinds of disorders share in common.
But I believe on cross you said something like 280. Was that the?
Yeah.
Is that the number?
Recent findings would be that about 288 different precursor diagnoses could lead to that.
Besides the approximately 4 criteria mentioned by Ms. Kappelman, there's 284 other criteria that someone could.
Other kinds of disorders with symptoms that could have a developmental course that looks similar.
And in your work in particular in this case, you've seen none of those criteria.
No, because I considered carefully all of the circumstances, that would help explain what it is that would lead him to feel that way or act that way. The circumstances including, not having an intact family, of having lack of supervision, of having, a developing brain with basically free time unsupervised, the understanding the neurobiological development of somebody, that they would be definitely attuned to high stimulus situations because that's developmentally appropriate for them. There are lots of things to consider.
Ms. Kappelman asked you about how many times you had testified for the defense and how many times you had testified for the prosecution. Could you be a little bit more clear on how many times for each? Not in a death penalty, just in a regular criminal setting. How many times have you testified for the prosecution as opposed to how many times you've testified for?
Sure. So I'm subpoenaed by the state, and sometimes that means that I sit at the courthouse and don't have an opportunity to testify. So I'd say the majority of the time in Florida, like 95% of the time, I'm going to be called as a defense witness. Either side can call me to testify at any point if I've submitted a report. It just depends if the defense publishes my report. If my position that I've offered to the attorneys is not helpful to defense, they just won't call me to court. And so, for instance, recently in Georgia, I testified in a murder case, insanity defense as the state's witness. And so that's an example where either party, could have called me, but obviously my position in that case would be more receptive, or the state was more receptive and had things that they wanted me to say on the record.
And what was your opinion in that case? I think
the person was malingering. Yes, and did not have a mental illness.
I'm sorry, could you explain to the jury what malingering is? Because I know, but I just recently learned that term. It's not a popular term, I don't think.
All right. So malingering would be a circumstance where a person would put forth that they've got psychological symptoms that they do not have, or they may be exaggerating greatly or malingering, the kind of embellishing the true symptoms that they do have. And the idea would be that it causes some benefit to them. So like in a Social Security disability context, they might seem really impaired.
So far into that doesn't have anything to do with this case.
Ms. Kappelman discussed that Mr. Garcia had not been diagnosed since his time with the DJJ. In your evaluation in this case, do you think that Mr. Garcia had an opportunity to be diagnosed, considering his lifestyle and the life he lived?
He didn't have insurance. That was a barrier to seeking services. And so if you're going to go and present at a physician's office, you have to pay the upfront, cash price for an evaluation. A psychiatrist as a specialist would have an enhanced rate that he would have to, pay for if he were going to seek out those kinds of services. And he directly told me he did not have insurance to do that.
Cool. Thank you, Doctor. No further.
Did you have a question at this point? Right. Not, you can step down.
Okay.
Take 10 minutes, let Jerry step out. You can step down. Everybody be seated. So where do we stand on the defense side?
No, nothing else, sir.
Right. Has Mr. Garcia made a determination that he does not desire to testify?
He's not going to testify, Judge.
Okay, if you would stand up, please, Mr. Garcia, and place him under oath, please.
Do you solemnly swear or affirm that the testimony you give is the truth, the whole truth, and nothing but the truth?
Going to state your name again, please.
Sigfredo Garcia.
All right, we had this conversation during the initial trial part. Do you remember that conversation?
I do.
Anything about that you're confused about?
No, sir.
You understand that you again have an opportunity to testify if you chose to. You understand that?
I understand.
Do you wish to testify?
No, sir.
Thank you, sir. All right. So the state's going to have some evidence.
Yes, Your Honor.
All right, we'll take 10 minutes.
Yeah.
State have rebuttal.
Yes, Your Honor. The state calls Dr. Pritchard.
All right. You'd face the clerk and be sworn, please, sir.
Do you solemnly swear or affirm that the testimony you give in this case is the truth, the whole truth, and nothing but the truth?
I do.
Have a seat. Light up the microphone, please, sir.
Thank you, Your Honor.
Please introduce your name, introduce yourself and spell your name for the court reporter.
My name is Dr. Greg, Greg. Last name is Pritchard, Prichard.
And how are you employed, Dr. Pritchard?
I'm a licensed psychologist in the state of Florida. I'm in private practice.
Could you briefly describe your training and experience in education?
Sure. I did my undergraduate work at the University of Florida. I attended Forrest Institute of Professional Psychology after I received my bachelor's degree. I received my bachelor's degree in 1989. Received my master's degree in clinical psychology in 1992. I finished my academic coursework in 1993 for my doctorate degree in the state of Florida. A requirement of the doctorate is 1 year of internship, which I did at Florida State Hospital in Chattahoochee. APA accredited internship. After I completed that, I was awarded my doctorate, graduated magna cum laude with my doctorate degree with a specialization in an academic specialization in assessment and diagnostics.
And what type of practice do you do?
It's a forensic practice. My 99% of what I do is forensic psychology, which means that I advise a trier of fact in criminal cases so that they can make an informed decision if there's an issue that's related to an individual's mental health, mental status. So again, 99% of what I do is forensic psychology. I've been doing it in full-time private practice since 2001, so for about 18 years.
Have you ever testified as an expert in the area of forensic psychology in a court of law?
I have.
All right, how many times?
Hundreds of times.
Judge, at this time, I would tender Dr. Pritchard as an expert in the area of forensic psychology.
Any board item?
No.
All right, Dr. Pritchard, could you kind of walk us through what it is that you were asked to do in this case and what items you reviewed in preparation for your testimony here today?
Sure. What I was asked to do, I was asked by the state attorney's office to do an evaluation of Mr. Garcia in anticipation of the penalty phase. I had a lot of information before I did the evaluation. I did not see Mr. Garcia until yesterday.
I had the investigative reports related to the criminal offense. I had a number of school records. I had Department of Juvenile Justice records on Mr. Garcia. I had a transcribed interview of Mr. Garcia. I had a transcribed deposition from Dr. Harper. I had medical records from the Mount Sinai Hospital, which I guess is in Miami. And that is the bulk of what I had. The DJJ records included things like predisposition reports from Bay Point and from other of the facilities that Mr. Garcia was committed to.
Right. And did you conduct an interview with Mr. Rivera in anticipation of your meeting with Mr. Garcia?
I did.
And the timing of your evaluation of Mr. Garcia, is that because you're not eligible to see him until there's a conviction?
Right. I'm not allowed to see him until there's a conviction. So the conviction occurred, I guess, Friday, and I was allowed to see him Sunday.
Okay. And were you able to observe the testimony of Dr. Harper in this case?
Yes.
Do you agree with Dr. Harper that Mr. Garcia suffers from major depression?
No.
Why not?
One of the important things I think in this case is there was a lot of good data. In other words, there's some cases where individuals do not have much exposure to potential help. Mr. Garcia was not one of those cases. So Mr. Garcia had a great deal of involvement in Department of Juvenile Justice. He's been to jail before. He's been to several Dade Marine Institute, Bay Point, like we referred to. So in other words, he had a lot of people that saw him through the process of his life. I never saw a diagnosis of major depressive disorder. I never saw that he was actually prescribed any medications for depression, which in my experience would be an unusual thing if a child is identified as having depression. Those are the kinds of facilities that are geared toward treating children and treating children with any kind of mental disorder that is recognized. So I didn't see any indication of major depressive disorder. One thing that needs to be said is major depressive disorder is debilitating. It's the most serious type of depression. Okay, when he was in Leon County Jail, he was not diagnosed with major depression. He was diagnosed with adjustment disorder with depression. That's a more low-level depressive disorder than major depressive disorder. It's basically a reactive depression. So if a person, for example, is experiencing things that make them feel bad, make them feel depressed, the appropriate diagnosis is adjustment disorder with depression. So I consulted a neighboring county, Gadsden County Jail, and that's the most common diagnoses we see with individuals coming into prison because they lose their freedom and they lose their ability to interact with family, and nobody likes being incarcerated. So it wasn't major depressive disorder that he was diagnosed with when he came to jail. He was diagnosed with adjustment disorder with depression, two very different issues. And again, I saw no indication historically that, he was described as pathologically depressed or described as not adjusting well because of depression or prescribed any medications designed to treat depression. So I wouldn't agree with that diagnosis because it doesn't seem to be supported.
And if he was suffering from major depression, would you expect to find some history of that illness?
Absolutely. Again, it's debilitating. It's a very serious issue, and usually the trained people, in other words, people in DJJ and in DJJ facilities, are able to recognize those issues generally in the adolescent population, and many adolescents are prescribed medications in those facilities. Again, that's part of what they're for. So I would expect to see some history and documentation and treatment for major depressive disorder if, in fact, it existed for Mr. Garcia.
All right. And what about the diazepam that Mr. Garcia was prescribed Did you hear Dr. Harper testify about that?
I did. That was in 2013. That would have been in reference to, I think the context was talking about anxiety disorder, complex anxiety disorder. The question was he treated for an anxiety disorder? The straight answer is no. No, he wasn't treated for an anxiety disorder. He was given an anxiolytic. It was a benzodiazepam at the hospital in 2012 or 2013. I can't remember which year. It wasn't prescribed for an anxiety disorder. It was prescribed for physical discomfort, physical pain. He was also prescribed Flexeril at the time, which is a muscle relaxer. So he had some kind of back pain, and the diazepam, the anti-anxiety, would be designed to relax. It's often given when people need to relax and go to sleep, or in his case, it wasn't an anxiety disorder. It was because he had some tight muscles and they were trying to help him relax.
All right. And while we're on the topic of the complex anxiety disorder, do you agree with that diagnosis?
No.
Why not?
For many of the same reasons as I stated in the major depressive disorder. He's never been treated for it. In the context of being exposed to a lot of people, a lot of professionals that were caring for him in the Department of Juvenile Justice environment, nobody diagnosed him with a complex anxiety disorder and prescribed any kind of anxiolytic medication that I saw. In fact, I according to Mr. Garcia, he said he did take some medications one time. I think it was in Bay Point while he was there. And that's the only time in his life he was prescribed any kind of medications for any kind of issue. He wasn't positive what the issue was. He wasn't sure if it was ADHD or maybe depression. He couldn't remember. But once he got out of that facility, he didn't take medications again until he apparently took some medications here at the Leon County Jail for an adjustment disorder.
And would being off medications for that long of a period of time be inconsistent with the diagnosis, complex anxiety disorder?
Yes, absolutely. Again, when you're you're treating children, you're looking for these issues that need to be addressed. You're making a treatment plan. You're making goals. It would be very inconsistent for all these people to see him and not diagnose, in my opinion, not diagnose these issues that will require medication, and to make that medication part of his follow-up, because he was in Dade Marine Institute. He wasn't taking medication, was in Dade Marine Institute either. He was there 2 different times. So it would be very inconsistent in my view that he would not be prescribed any medications by these people that are treating him.
And Bay Point and Dade Marine Institute, are those both Department of Juvenile Justice detention facilities?
They are Department of Juvenile Justice detention facilities for individuals, youth who commit crimes. So they're arrested or adjudicated for some kind of criminal offense as a juvenile, and Department of Juvenile Justice has these facilities that the court often commits the children to for punishment and care.
And what was the problem with Mr. Garcia, according to the mental health professionals that saw him in his youth?
Generally, the problem was a lot of criminal behavior, and just difficulty adapting in school, poor grades, that kind of thing. But the key would be, for me, the criminal behavior. If I look at Mr. Garcia's records, okay, the thing that does not stand out is treatment for mental health symptoms, anxiety or depression. It's nowhere. What does stand out is the criminal behavior. Okay, a very unusual thing. Youth sometimes get arrested, but youth getting arrested as frequently as Mr. Garcia is very unusual. It's very unusual for a child to get arrested at 6 years old. Not a common thing at all. We rarely see it. When a youth gets arrested once or twice, it doesn't really mean anything. All youth can be errant in terms of their judgment and behaviors sometimes. The issue is when it's repeated. Okay, it's repeated. So that's called criminal recidivism. So when we see a child get arrested and have some sanctions, it disrupts his life. He loses his freedom. A lot of things that are a consequence of that criminal conduct, and then do it again, and then do it again, and then do it again, and then do it again. And that's on and on. So I counted 20 arrest reports on Mr. Garcia between 1988 and 1999. The 1988 one was when he was 6. The 1999 would have been when he was about 17. 20 arrest reports related to stealing cars, related to robbery, related to an allegation of arson. So very unusual. So in my view, that's what stands out. And if you're going to assess Mr. Garcia, pay attention to what really stands out over the course of time. And for me, it's that.
And what does that mean? The fact that he has criminal recidivism in his record?
Well, I mean, in terms of diagnosis, that's what we as forensic psychologists are trying to do. We're trying to sort out what are the issues that this particular individual presents with. Can be anything within the realm of possibility in terms of from a psychological perspective. Over the course of time, we try to narrow it down. We're looking at all the information. We want to narrow it down. Does it look like this individual has a number of diagnosable mental illnesses like depression, like anxiety, like PTSD, et cetera, or does it look like he has some personality issues that generate this criminal conduct primarily and really affect the person's adaptation? So when we see that criminal conduct, in my view, absent in the intervention, absent any recognition of any depression or anxiety or anything else for that matter, the criminal conduct is indicative of those personality disorders, that those personality issues. We have diagnosis for it. In youth, it's called conduct disorder. Conduct disorder are kids who do not follow the law and the rules that are in place for them and their peers. In other words, they break the law repeatedly, get suspended, get expelled. So if you see that kind of behavior, Mr. Garcia was expelled from middle school, had something like 4 or 5 suspensions according to him, but had arrests throughout his youth. That's clearly indication of a conduct disorder that we look for in the forensic world.
And so is it your opinion that Mr. Garcia did have a conduct disorder as a youth?
I don't think there's any question about it. I don't think you could not say that that's true given the criminal conduct that he demonstrated.
And how does that carry over into adulthood, or does it?
Well, sometimes it does and sometimes it doesn't. When it does, what you see is a continuation of that kind of behavior. In other words, the criminal behavior once the person reaches 18. So we see that it begins in their youth and it continues in spite of sanction. It doesn't change the conduct. Even when they get a little older, they keep doing it. So when we see that continue into adulthood, it is called antisocial personality disorder. That's the term for it. It's also known as the criminal personality. Individuals who continuously break the law, that's the central feature. So a continuation of conduct disorder into adulthood is called antisocial personality disorder.
Okay. And did Mr. Garcia, in your opinion, exhibit any other criteria or diagnostic features of antisocial personality disorder?
I mean, I think he clearly has features. I think that he has also mellowed some in his adulthood. In other words, he didn't commit criminal offenses as consistently since he's been an adult as he did when he was a child. So it's mellowed some. So I would say that there are certainly features of antisocial personality disorder, which I think describes Mr. Garcia the best. In other words, he's a capable guy. He's a smart guy. He could have done a lot with his life, were it not for the choices he made in terms of his criminal conduct. Those choices repeatedly are really what has disrupted his life the most, nothing else.
All right. What other features did you observe? You said he certainly has some of this. antisocial features? What are those?
I mean, he has, we heard talk about irritability sometimes. There is irritability. So irritability and aggressiveness is a feature of antisocial personality disorder. The crime itself is, you often see these types of crimes, the people who commit them often have this pattern of criminal conduct leading up to that crime, in this case, murder. So you often see the failure to conform behavior with respect to lawful conduct lifelong, which he has expressed. So that's a central feature. That's the most important feature. We also see impulsivity, where he doesn't plan real well. There's elements of planning in some of the things he does, but a lot of times he's impulsive and doesn't make good decisions.
All right. And did you hear Dr. Harper talk about the lack of empathy?
Yes.
And do you have an opinion on that?
I do. It's a good one. It's a good one as a feature of antisocial personality disorder. And I think her point was, listen, I talked to a lot of his friends, and all the friends say he has great empathy. Okay. Now, there is not many people who don't have any empathy at all. Okay. But it is a feature of antisocial personality disorder. So my point would be this: when you are committing criminal offenses, when you're stealing people's property, stealing people's cars, money, whatever, when you commit this crime that we're here on, okay, think a little broader. The crime that we're here on, the children of Mr. Markel. I mean, Mr. Markel's family, the mom. That's empathy. People often have moral breaks, and they don't engage it because they don't want to hurt these people. And his unwillingness to do that is classically lack of empathy, in my view, especially coming from somebody who apparently should have known the effect of losing dad when you're young, and a willingness to do that himself with the case we have here is a lack of empathy.
And how does substance abuse play into this analysis?
I mean, he's a substance abuser. There's no question about it. He's been abusing substances for a very long time. I would disagree a little bit with Dr. Harper in terms of, I think cocaine was the primary drug he liked. He liked the things that kind of amped him up. Also liked marijuana a lot, which of course didn't amp him up. It kind of slowed him down. But those were his two drugs of choice, were the cocaine and the marijuana.
Did you agree with Dr. Harper that he only uses these substances to self-medicate when he's sad or depressed, or does he just like to drink and party?
I mean, I think that's one of the most overused term there is self-medicate. So a lot of people use drugs because they like it. I even saw where Mr. Garcia said in one of his juvenile records that since the first time he took a hit of pot, he liked it. He's always used it. He doesn't intend to stop. So, people use substances for different reasons. My view is that he used substances because he liked to use substances, just like Luis Rivera. They did that together, and it was a party atmosphere. It wasn't, to self-medicate. It was to get high and to get drunk.
Do you agree with Dr. Harper's characterization that Mr. Garcia's recklessness or lack of empathy on some of these instances was just from a place of self-loathing? She said, oh, he doesn't care if he lives or dies. He's not really putting other people in danger.
No, I mean, I heard that, and I do not agree with it. Number one, you see that characterization of Mr. Garcia for much of his life as a daredevil, jumping off things, doing backflips. That's putting himself at risk, but also these traffic offenses. He's had a lot of arrests for traffic offenses, things like speeding, things like passing too closely. He's a reckless driver. He's also had the incidents of accident that we've seen, at least two on a motorcycle. One time he was by himself, told me that he was going over 100. Another time he wasn't by himself. He had a female on the back. of his motorcycle when he crashed it, and they both got injured and had to go to the hospital because of it. Very reckless, not on just that occasion, but it seemed to be a fairly consistent characterization of him. I wouldn't attribute it to self-loathing. I would attribute it to kind of being that adrenaline junkie, liking fast, likes to race, likes to do the criminal thing in part because there's an adrenaline rush for that.
And doesn't really seem to have much empathy for how it affects others.
No, I mean, he puts others in harm's way when he's driving the way he's driving, when he's stealing cars, and when he's doing the other things he's doing.
And he's coming to Tallahassee and killing Mr. Markel.
I agree.
One moment, please, Your Honor. No further questions.
Problem.
Just 1 second, Judge.
Yeah.
All right, come to order. Court is now in session. Jury. All right, for the jury.
Everybody be seated, please. Good morning, folks. Thanks for being back here this morning. At this point in time, now I'm going to instruct you on the law. Again, you'll be allowed to keep these jury instructions. So you don't need to make any notes unless we find a typo or some mistake that we need to fix. Again, what I would ask is that you read along with me as I go through them so that I can be certain that everyone's been through their
in their entirety on at least one occasion. Members of the jury, you have heard all the evidence, and it's now your duty to make a decision as to the appropriate sentence that should be imposed upon the defendant for the crime of first-degree murder. There are two possible punishments: life imprisonment without the possibility of parole, or death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No facts other than proven aggravating factors may be considered in support of a death sentence. The aggravating factors alleged by the state are: the capital felony was committed for pecuniary gain, and 2, the capital felony was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. You have heard evidence about the impact of this murder on the family, friends, and community of Daniel Markel. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by Daniel Markel's death. However, you may not consider this evidence as an aggravating factor. As explained before the presentation of evidence, the state has the burden of proof an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in providing a verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravated factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether or not you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility for parole. At such point, your deliberations are complete. If, however, you unanimously find that one or more aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. If you do unanimously find the existence of at least one aggravating factor and that the aggravating factor is sufficient to impose a sentence of death, the next step in the process is for you to determine whether any mitigating circumstances exist. A mitigating circumstance is anything that supports a sentence of life imprisonment without the possibility of parole, and can be anything which might indicate that the death penalty is not appropriate. It is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may reasonably indicate that the death penalty is not an appropriate sentence in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only establish a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to be imposed. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are: 1, the first-degree murder was committed while Sigfredo Garcia was under the influence of extreme mental or emotional disturbance. 2, Sigfredo Garcia was an accomplice in the first-degree murder committed by another person, and his participation was relatively minor. 3, Sigfredo Garcia acted under extreme duress or under the substantial domination of another person. 4, the existence of any other factors in Sigfredo Garcia's character, background, or life, or the circumstance of the offense that would mitigate against the imposition of the death penalty. Your decision regarding the appropriate sentence should be based upon proven aggravating factors and established mitigating circumstances that have been presented to you during these proceedings. The next step in the process is for each of you to determine whether the aggravating factor or factors that you have unanimously found to exist outweigh the mitigating circumstance that you have individually found to exist. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or value by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance. Regardless of the result of each juror's individual weighing process, even if you find that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. The jury's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat what I've said, If your verdict is that the defendant should be sentenced to death, your finding that each aggravating factor exists must be unanimous. Your finding that the aggravating factors are sufficient to impose death must be unanimous. And your finding that the aggravating factors found to exist outweigh the established mitigating circumstances must be unanimous. And your decision, if to impose a sentence of death, must be unanimous. You will be provided a form to reflect your findings and decision regarding the appropriate sentence. If your vote on the appropriate sentence is less than unanimous, the defendant will be sentenced to life in prison without the possibility of parole. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your verdict. Please also rely on the instructions I gave you previously in the first phase of this proceeding trial. And if you need copies of that, just let us know. We will get you a copy of that. Let's give them the verdict form. Everybody have a verdict form? Let's look at it. It is a little confusing. We'll make sure you understand. So step one, we the jury find as follows as the aggravating factor. Remember, the state is alleged two aggravating factors. Either the capital felony was committed for pecuniary gain, or the capital felony was cold calculated, premeditated. You would check whether you unanimously find that the state proved beyond a reasonable doubt this aggravating factor. As to each of the aggravating factors, you would make that determination. If you find that the state has proven no aggravating factors, in other words, have proven neither of the two, then your job is completed. Your foreperson should date and sign the verdict form, and you do not need to move forward. If you find that at least one aggravating factor has been proven beyond a reasonable doubt, then you would go to step two. There you say, we the jury find as follows: as the sufficiency of the aggravators, the state proves beyond a reasonable doubt that the aggravating factors are sufficient to warrant the sentence of death, or the state did not prove that. Again, you would check your option there. That's unanimously proven by the jury. If you find the state did not prove that the aggravating factors are sufficient, you would date, sign the verdict form. Your job would be completed at that point in time. You don't need to go forward. If you find that the aggravating factors are sufficient, then you would go to step three, similar determination. You decide what you, in weighing the aggravating factors and mitigating circumstances, the state proved beyond a reasonable doubt that the aggravating factors outweigh the mitigating circumstances, or the state did not prove that. You would check that option. If you determine they did unanimously, then you would go to step four. If you find they did not, you would date and sign the verdict form. Your job would be completed. And then step four, we the jury unanimously find the state proved beyond a reasonable doubt that the appropriate sentence is death, or one or more jurors find the appropriate sentence is life imprisonment without the possibility of parole. Obviously, the first option has to be unanimous. The second option does not have to be unanimous, but you would check whichever you have determined be dated and signed by the foreperson. I know that's a little bit confusing, but it's a 4-step process. The state has to prevail on each of the steps for you to move to the next step. At this point in time, the attorneys will be allowed to make their concluding remarks. The state will go first, the defendant will follow. There is no rebuttal argument, so there are just 2 arguments. We'll start with the state of Florida.
May it please the court, counsel. Members of the jury, good morning. You got a chance to learn a little bit about the unique life of Dan Markel and his unique contributions to our community through the victim impact statement of his mother. And you learned that he was a gifted legal scholar, a devoted father, and that he is desperately missed by his family, his students, his colleagues, and the legal community. His life was cut tragically short by the reckless and incredibly callous and cold actions of this defendant, Sigfredo Garcia. There is no evidence that this defendant's role in this crime was minor or that he was merely an accomplice, as all the evidence indicates that he is in fact the one that pulled the trigger. The shots in this case were fired at close range, as you can see there in State's Exhibit 8, close enough to deposit soot on the face and arm of Mr. Markel as he raised his arm to protect himself. The height of this bullet is consistent with the taller of the 2 men that we know were there at the scene. And the accuracy of that shot is consistent with a straight on shot, close range, as you know, as opposed to a gangster style shooting. In the bus video captured moments after the crime, we see clearly the passenger in the white shirt, the driver's in a dark shirt. Consistent with the physical evidence on the scene, meaning the taller shooter, the passenger, the evidence discovered at autopsy, meaning the accuracy of the shot and close range nature of the wounds, and the testimony of Luis Rivera. It doesn't make sense for the shooter to also be the getaway driver, and all the evidence in the case points to Sigfredo Garcia, the taller of the 2 men, the one in the white shirt, the one in the passenger side, the one that Luis Rivera says got out and fired 2 shots at Dan Markel. Cold, calculated, and premeditated. Cold means the murder was the product of calm and cool reflection. So time to plan, time to reflect, time to rent a car in June of 2014. There is no evidence that the defendant was under the domination or control of anyone when he went to the comfort rental car and rented this car in June of 2014. And then he drove 500 miles from Miami to Tallahassee, Florida. Katherine Magbanua wasn't in the vehicle. She wasn't exercising domination over him. He had enough reflection to get a couple guns for the trip in anticipation of murdering a man that they had never met and had no beef with. Garcia doesn't seem to be experiencing major depression when he's partying with Shadrach Nobles at the Budget Inn. Calculated means having a careful plan or a prearranged design to commit murder. In this case, they were careful enough to follow and stalk their victim at his home, at his children's daycare, at his gym. And when the timing wasn't right on this first trip in June, they were patient enough to return home. And then 6 weeks later, return again to Tallahassee, another 500 miles. So they traveled approximately 2,000 miles Absent the 500 miles that happened after the murder to get home, that's 1,500 miles in 6 weeks to reflect and formulate the plan to murder Dan Markel. 1,500 miles to think about what it takes, what it means to take a life. 1,500 miles and 46 days between the time that first car was rented and the time that this man put a bullet in Dan Markel's head to change his mind, to back out. But that was not the choice he made. This is an intelligent man, this defendant, capable of getting a GED and working in the field of aeronautics. Garcia wasn't experiencing a bout of PTSD when he shot a hole in his Prius. He wasn't suffering any extreme emotional disturbance when he fixed that vehicle. And he wasn't under the domination of Katherine Magbanua when he sat outside the Premier Gym and waited 1 hour for Mr. Markel to complete his workout, patiently waiting, stalking his victim. He was calm as they followed Markel to his residence. At 10:44 a.m., all he had to do was call it off. Head home. They're right there by the I-10 exchange. Tell Luis Rivera, get on I-10, we're going home. But that was not the choice that Sigfredo Garcia made. At 10:51 a.m., another chance to back out, another chance to reflect on what it was that he was about to do. To take a father away from 2 little boys. The irony of him asking you to show mercy because of his lack of a father should not be lost on you. That mitigating circumstance as presented by the defense to you should be given very little weight, as he made the choice to take this father away from his children. Why did Mr. Garcia execute this man he never met? Was he under extreme duress? Was somebody forcing him to do it? No, he did it for money. This was a murder for hire. Katherine Magbanua didn't have to force him to come to Tallahassee or do anything. He wasn't under her substantial domination. He wasn't even with her. She wasn't even here in Tallahassee when he did this crime. And when he went home, he didn't see her then either. They met and then he went and stayed at Shrimp's house. He had to be retrieved from Shrimp's house the next morning to come and collect his money. Then what? Extreme duress? Emotional distress? No. He and Rivera went out and partied that night. Here's a picture of them from Facebook. They went out and spent their money, celebrated. He bought toys with his money that he got payment as for this brutal murder. He wasn't suffering from mental illness, as Dr. Harper would have you believe. He wasn't driven to this crime by anxiety or depression. He didn't do this because he had a crappy father or because he likes to snort cocaine. He did it out of greed, and he did it because he has a criminal personality, as discussed by Dr. Pritchard. This criminal personality or antisocial personality is characterized by his extensive criminal history, which dates all the way back to early childhood, his impulsivity, his irresponsibility, and recklessness, and also by a lack of empathy toward the collateral damage that his wake of destruction leaves behind. Mr. Garcia chose the lifestyle which included drugs and booze and 100-mile-an-hour wipeouts. This moment here today is a culmination of all the choices that he has made in his life. Dan Markel didn't get a choice in any of this. His death was the product of a cold, calculated act driven purely out of greed. The aggravators in this case have been proven beyond a reasonable doubt, and they outweigh any mitigation that you might find that the defense has presented. You should now bring your best judgment to bear in making a decision as to what the appropriate sentence is for what this man did. And that judgment should be a recommendation of death. Thank you.
Should sound good.
Your Honor, Ms. Kappelman, Ms. Norris, ladies and gentlemen, the ultimate decision is upon us, right? And the steps that the court and the law require you to take, it's not an easy, it's not a short journey. You don't get to go back there and go, life or death. There's steps. There's 4 of them. And the reason why there's 4 steps is to show you the importance of this decision. Now, what the government is asking you to do is to take 2 aggravators, which is money and premeditation, okay? And make that appear to be such a unique scenario in this case, but it's not. How do you think most murders happen? For money and premeditation. First-degree murders require premeditation. What sets this murder apart from others? That's the question you should ask. What requirement should I have? What standard should I set to sentence somebody to death? 4 victims, children, terrorists, mass shooting. Those, I implore, are situations where the death penalty is appropriate. By no means am I mitigating the loss of Mr. Markel. But the options aren't death and a walk. It's death or life without the possibility of parole, which means regardless of your choice, Mr. Garcia will never step outside a prison. He will never get to walk outside of a restricted facility. So believe me when I say this to you, life in prison is no walk in the park. Let's talk about the 4 steps. The first step is if you believe that these aggravators are applicable beyond a reasonable doubt. The same standard you guys made a determination of as to innocence or guilt. It's a high standard, okay? So let's just give the government, in this hypothetical, the benefit of the doubt, and let's say you find both, or one. You get to go to the next step. And the next step asks you, are these 2 aggravators or 1 aggravator enough to kill somebody? And if one of you doesn't believe that that's the case, then that's it. If one of you believes that life in prison is the appropriate charge, that's the charge. That's the punishment. And if you're one of these people that believe that this is a scenario that life in prison has to be the just result, stick by your guns. This is a scenario where if you believe that life is the right choice, that life is the right punishment, if life is the appropriate sentence, then choose life. And that's step 2. Because if you don't believe a murder for hire, or in essence, money for a killing, which I think those 2 things go hand in hand. And if you think to yourself, well, you know, if the government sought this punishment for this case, how is it different than other murder for hires or other robberies that result in murder? Let's talk about the mitigating factors that we're asking for you to consider. The first one is that Sigfredo was under the influence of extreme emotional or mental disturbance. Well, let's look at the trial, right? Let's look at the trial and remember what happened in the trial. Let's remember the fact that Katherine Magbanua had done it, and everybody had indicated that he was spiraling out of control. Even Luis Rivera, the government star witness, this was the only thing that I agreed with him. That Sigfredo was spiraling out of control because of his breakup with Katherine Magbanua, which goes in concert with what Dr. Harper said. Listen, remember who we're talking about. A guy who really didn't have a dad that gave him coke and weed, taught him how to commit crimes. This kid was arrested when he was 6 years old. In and out of the system, in and out for little petty stuff. And then when he became an adult, he was doing better. You know, the government brought up this robbery that happened in 2012. And we brought up, wait. There's 2 people that was arrested. One got 8 years. Sigfredo got a day. And what kind of criminal history did they bring up other than those 2? He hadn't been in trouble in years. And even Dr. Pritchard told you he was writing his life. I'm going to skip to number 3 because that's what I want you to think about the most. If he was under the domination of another person, and I told you during my opening argument, look at the trial, look what happened. Katherine Magbanua sat there and her lawyers pointed at Sigfredo, right? They even had a chart where they took his picture out and made Sigfredo the key to this case. And what did we do? You don't think we saw that coming? Saw that a mile away. Did we point the finger back? Do you not think that as a legal team, we wanted to provide Sigfredo with the best, smartest defense? Why do you think we didn't point a finger back? Who is he trying to protect from the beginning till now? And if you don't think that this woman had complete domination, I mean, the government sits here and during the trial, they go, oh, look at all these phone calls between them. Look at her blowing up his phone, this, that, and the other. Yeah, she did it. She had complete control over Sigfredo Garcia from day one. Day one. And now they want you to ignore the fact that during the trial, they told you over and over, she's calling him. She would call 19 times, no answer. That right there, that in and of itself, that's enough. That mitigator outweighs those aggravators by a mile. You know, we want to talk about his drug addiction and terrible situations that he put himself in or that he's dealt with. Yeah, he has. He's had a difficult life. No father, getting in trouble, and then realize when you become an adult or when you're becoming an adult, because what did they tell you? They told you about these records in the Department of Juvenile Justice from when he was 6 to 15. I mean, you know, I don't know about you, but I didn't know who I was back then. I became a man in my 30s, me. I didn't really know who I was then. He started figuring out who he was in his late teens. And you know what that meant? Oh, I've been arrested. I've got a record. My life, that path to being a good father and being who I wanted to be from day one, since I had a terrible father, that path's not easy. And listen to what I'm asking for. I'm asking for life in prison as opposed to death. You guys have the opportunity to walk back there and walk right out. The people here that believe that life is the right choice, that's it. Knock on the door. Because that's what we're asking for. We're asking for life in prison. We're asking for life in prison versus death. Because I don't think death is appropriate here. And I don't think that you think it is. I think that the fact that we've shown the mitigator of dominion and control by Ms. Magbanua, I think that outweighs everything. Because what did the evidence show? He hated Charlie Adelson. He was going to take him deep sea fishing. He cut him off at her house. Right? We all agree with that. There was text messages to prove it and phone calls where they joked about it. And this man had to sit here and hear how the love of his life played him for years. And he still didn't want us to hurt her. And if you don't think that's dominion and control, then that's fine. Because what can I do? I can only show you the writing on the wall. And all I ask is that you show me the fact, and you just show me that you see it. And that factor in and of itself should be enough. Now, there's others. We believe, and we've told you that Luis Rivera, it's been our position, it's been the shooter. And I know you found him guilty of first-degree murder, and we respect it. But if you believe that there's a principal theory and that Luis Rivera was the real shooter, that should be something considered too. You know, we find ourselves in a scenario where we're asking you to choose someone's fate, the ultimate fate. And we're asking you to consider those 4 steps. All 4 of them don't need to be taken. If we get to step 2 and you want to jump off, jump off. If you get to step 3 and you want to jump off, jump off. And if you get to step 4, jump off. Give this guy life. That's the appropriate sanction in this case. Thank you so much.
Let's go back to page 5 of your jury instructions, please. Submitting the case to the jury. In just a few moments, be taken to the jury room by the bailiff. When you have reached decisions in conformity with these instructions, the appropriate form should be signed and dated by your foreperson. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case, and you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices with the bailiff. It says here to leave it on your seats. Don't do that. Give them to the bailiff. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I've given in this case, you must tell me by giving a note to the bailiff. During this trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The exhibits will be sent into the jury room with you when you begin to deliberate. I cannot participate in your deliberations in any way. Please disregard anything I may have said or done that made you think I preferred one decision over another. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. In closing, let me remind you that it is important that you follow the law spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we've lived by the Constitution and the law. No juror has the right to violate rules we all share. Let's go sidebar, please. right. Mr. Barton, you need to remain here with us. Rest of you may step out, begin your deliberations. Will we send in the evidence? Let everybody be seated, please. So, Mr. Barton, this will conclude your service with us. I do appreciate you coming back. I know it was some inconvenience to you, but we're always worried we lose somebody along the way, and then we have to start all over again. So appreciate your service to us. Let me make you aware of one right that you have. You have a right not to discuss anything about your jury service. It may be that someone would contact you. It's probably not unlikely that someone would contact you. It's up to you whether you wish to discuss it or not. You're free to if you wish, but you're also free to just say, I'd prefer not to talk about it. That's up to you. We appreciate you being here with us. We'll let the bailiff get you out of the building and let you get on your way. Thank you for your service.
You're welcome.
Have a good day. Do you need this letter, Mr. Barton, from the clerk?
Probably not. I'll take it.
Okay, stand by here.
Can you retrieve this? You can't get that. Okay. All right, everybody be seated. Let's discuss a couple of things. And just a second, I'll let y'all. Is the evidence in the same separation it was at the end of deliberations? Do you feel like the lawyers need to go through it again?
No, I double checked everything. It's
All right.
on the order.
You've separated out what was for identification only,
Yeah.
and you've separated out what was just put in this proceeding. So,
Yes.
all right, when we break, if y'all want to give a quick scan of the evidence, you're welcome to do so. It sounds like she's got it separated out. Let's talk about a couple of things first. If there is a life recommendation from the jury, will the defense be ready to proceed to sentencing since there's only one sentence I'd be allowed to impose?
Yes, sir.
All right. We'll need a score sheet available for that, so go ahead and prepare that, Ms. Kappelman, so we won't be delayed on that. Mr. Evans said there was some victim impact information that you wanted me to consider. You'll give me that. I'll review that in the interim. Mr. Sanger, have you discussed with Mr. Garcia representation on appeal?
Judge, as we indicated early on in the case, he became indigent, and so unfortunately, and our office does not do appellate work. So we would ask, I don't know if he needs to be declared indigent again.
Well, that's why I brought it up. Why don't you get a PD affidavit from the clerk and fill that out? And of course, it's still your obligation to perfect the record and file the notice of appeal. But once you've done that, if we have the PD affidavit, you can file your motion to withdraw and allow the public defender to take over the appeal. Anything else from anybody?
Not for Mr. Garcia.
State, anything?
Judge, I've marked as State's Exhibit 200, a court exhibit which contains the PowerPoint which the state presented in closing for penalty phase.
Okay. For record purposes only, it's not to go to the jury. So why don't y'all scan the evidence for it sent to the jury? With that, we'll be in recess till we hear further from the jury. And if you need one more thing to do, I will need mail credit. Okay.
All rise. Court's now back in session.
Cemetery, please.
They don't have a decision.
What's that?
I asked the jurors, I was coming up to ride. I don't understand if that's okay.
Okay.
Jury's in the courtroom.
Everybody be seated, please. Russ Meisel, is the jury arrived at a verdict?
Yes, sir.
We have handed the bailiff, please. State of Florida versus Sigfredo Garcia, we, the jury, find as follows: as to aggravating factor, the capital felony was committed for pecuniary gain. The jury has found the state proved beyond a reasonable doubt that this aggravating factor exists. We, the jury, find as follows: as the aggravating factor of the capital felony was a homicide and was committed in a cold, calculated, premeditated manner without pretense of moral or legal justification. Jury has found the state proved beyond a reasonable doubt that this aggravating factor exists. As to step two, we, the jury, find as follows: as sufficiency of the aggravators, the state proved beyond a reasonable doubt that the aggravating factors are sufficient to warrant a sentence of death. As to step three, we, the jury, find as follows: as the weight of aggravating factors and mitigating circumstances, the state did not prove beyond a reasonable doubt that the aggravating factors outweigh the mitigating circumstances. It's dated and signed by the foreperson. Having made that conclusion, there was no reason to go to step four. Either side wish to have the jury polled?
No, sir.
No, Judge.
This will conclude your service with us. We do appreciate the time and the attention that you have given us. I know it's been a long and arduous experience for you. We very much appreciate the time and the attention that you've given us. You've been very cooperative, and we appreciate that. You've been a very reliable jury. I try to run things on time, and y'all have by and large cooperated very much with that, and I appreciate that. Once you start letting things get out of whack on that, you end up sitting in the jury room a long time, and I try to avoid that. Let me discuss a couple of things with you. It is quite possible that you will be contacted by someone to discuss your deliberations. You're free now to talk about it if you wish, but I want you to understand you also have an absolute right not to discuss your deliberations. You have every right to simply say you'd prefer not to talk about it. Again, that's up to you. I don't know what kind of person you might be contacted by, but you might be contacted by someone wishing to find fault with what you've done. As I've said, you have every right to simply say you prefer not to talk about it. You will be receiving a letter from the court with our thanks. It will include in that an opportunity to seek counseling that we have arranged. That's, something for you to decide. It won't be long-term, but they will at least you get started with some free counseling that the court has arranged. Then from there, you can decide how you wish to proceed. Sometimes we don't think about the impact we have on jurors. I do try to consider that, and that's something that we have arranged. You're done now, so I did want to comment on one thing that you were not advised of, just in case it's something that you were curious about. I know you've been kind of cloistered from hearing about the case. in Ms. Magbanua's situation, let you know that the state was not seeking the death penalty. As to her, I don't know whether that was something that maybe you were curious about, but pondered that maybe some of y'all might be wondering what that situation was. It was decided before trial that you were not to be told that, for various reasons. So, but I thought that might be something you would be interested in knowing. That matter will be reset, and we have not picked a new trial date on that, but eventually we will have a new trial date, and that matter will proceed. So probably longer than y'all wanted to hear. I know y'all ready to get out of here. We do appreciate all the time and attention that you've given us. We'll let you step out. The court administration people will get you out of the building. Have a good day. Thank you. I'm gonna need about 25 minutes. We're gonna proceed on this sentencing. I haven't finished my reading, so I'll reconvene at 11 o'clock and give me a chance to finish the reading on what's been provided to me. So we'll reconvene for sentencing at 11 o'clock. Huh?
Yes, sir.
Ladies and gentlemen, if I can ask you for your patience, give us just a few minutes to get these jurors out of the zone.
Who, me? What time did he say? I was in there. What time did he say? What time?
11.
Okay. 20 minutes left. So do they all have to be back at 11, which is 20 minutes from now?
Oh, they're going, right? Oh, I guess.
Well, that's why I mean, again, I do want, what I'm just saying is, I'm making myself available. If you want to sit there and talk about it. Well, they say. That's fine, too. I just didn't know. I know you did. What I can do is No, that's not a good idea.
Not looking at you either.
I just put coffee in our DCA. I was there.
Your brain is crazy. Your brain is like this.
Yeah, I'm rapidly trying to make things.
What's the big thing?
Okay, can I please? I'll tell you the truth.
Oh, you were telling the truth?
You don't know me by now. Court back in session. Be seated, please, folks.
Would you treat that as bad? Is there any reason not to proceed to sentencing at this time?
No, Judge.
No, sir.
Any technical objection to the score sheet?
No, Judge.
Defense wish to be heard.
No, Judge.
Does Mr. Garcia want to say anything?
No.
All right. State.
Judge, the state, obviously you can only do one sentence, but the state would request a 30-year consecutive sentence on the conspiracy charge. And we do not have any evidence to present other than the statements that Your Honor has already reviewed.
Sorry, I left that notepad on my desk. Excuse me. Yeah, hard time finding it. We'll take this there.
Remain seated.
I have reviewed the victim impact letters. Thoughtful and touching comments. Sanguinic, come forward with your client, please. As the jury, having found you guilty of murder in the first degree and conspiracy to commit first-degree murder, I do adjudicate you guilty of each offense. On count one, I sentence you to life in prison. Give you credit on that sentence of 1,238 days, which dates back to May 25th, 2016, which I understand to be the date of arrest. On count 2, I sentence you to 30 years, Department of Corrections, to run consecutively to count 1. There's no jail credit as to count 2 since it is a consecutive sentence. As to count 3, based upon the jury verdict of not guilty, I adjudicate you not guilty of that offense. Order mandatory cost $420, $100 cost of prosecution. Reduce that amount to civil judgment. Mr. Garcia, you have 30 days to file a notice of appeal. If you can't afford a lawyer, one would be appointed to represent you. And I would assume, Mr. Sanguinetti, you will assist him in getting the appeal filed and the record perfected.
Yes, Judge, we did provide the clerk, I don't know if we provided it yet.
Yep.
We have provided with an updated financial affidavit.
Did you review the affidavit? We'll take that up because you need to perfect the record before you move to withdrawal, but we'll review that at that point in time.
Yes, Judge.
Does that leave anything outstanding from anyone?
No, sir.
Anything further?
No, Judge.
All right. Good luck to you, sir. We'll be in recess.
Your Honor, may I go?
Sure.
Thank you for the
Appreciate your work. Very good lawyer. Appreciate it. Excellent. Go big, get these.
Thank you.